for this interview. We would like to welcome you to feel comfortable and to feel at home and to consider this interviewing panel as one that is created to facilitate the process of determining whether you would be considered and recommended for appointment to the position of Deputy Chief Justice. Before we begin, we'll ask the commissioners to introduce themselves, starting with the commissioner on my far right.
My name is Tuila Amos Wako, Attorney General.
Welcome, Gladys. My name is Emily Ominde. I am a Principal Magistrate representing Kenya Magistrates and Judges Association.
Welcome. My name is Ahmed Nasir Abdullahi. I'm an advocate of the High Court of Kenya. I represent the Law Society of Kenya and its members in the JSC. Welcome.
Isaac Lenaola, Judge of the High Court. I represent the High Court.
Good morning. I'm Florence Mungangi. I am an advocate. I represent the Law Society of Kenya.
Good morning. I'm Christine Mango. I represent the 40 million Kenyans, including yourself and all these members here. Thank you.
And my name is Titus Gatere, Chairman, Public Service Commission of Kenya. I am interimly chairing this particular session. We want to welcome you once again, and the first question will be you tell us something about yourself. Take 2 minutes, summarize, and restrict yourself to academic and professional qualifications. Experience, the questions on experience will come later.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, and good morning. Thank you, Commissioners, and good morning. My names are Gladys Boss Shollei. I'm currently the Deputy Chief Electoral Officer at the Interim Independent Electoral Commission. Before I explain my academic and professional qualifications, indulge me for a minute to say that I would like to commend this panel for this extremely transparent process. Never mind that it's very intimidating. But for many years I watched the US Senate confirmation hearings and looked at the senior officials being questioned in such a panel that was open and public, and I thought that's democracy at its best. I never knew that one day it would happen in my country, let alone in my lifetime, and furthermore that I would be part of this process. I commend you for that, and I thank you, and I feel privileged to be part of this new part of history. Going to my academic qualifications, I hold a Bachelor of Laws degree from the University of Nairobi. I hold a postgraduate diploma from the Kenya School of Law. I hold a Master of Laws degree, LLM, from the University of Cape Town, South Africa. I also hold a Master of Business Administration degree from MBA from Jomo Kenyatta University, Nairobi. I'm an advocate of the High Court of Kenya and a certified public secretary, CPS. I have also attended several professional development courses, which you will see in my profile and folder that I gave. The most recent being 2 weeks ago to the leadership program at Harvard Business School. I have endeavored throughout, and you will see in my documentation, that I have strove for excellence and professionalism and academic excellence, and therefore have continuously attended self-improvement programs throughout my professional career. Going to my professional experience.
I think let's leave it as that, so that Commissioner can ask you specific question about experience. Commissioner Lenaola.
Thank you very much. Allow me to call you Gladys.
Yes.
Gladys, having told us then about your academic qualifications, perhaps you can tell us then what has been your professional life like? Where have you served? In what capacities? Up to date.
Thank you, Commissioner. As I said at the beginning, I am currently the Deputy Chief Electoral Officer at the Interim Independent Electoral Commission. My job description includes supervising the portfolio of the core business of the Commission, which is election operations, voter registration, political parties, voter education, and partnership. I'm also in charge of all the regional offices throughout the country and its election managers. I also do advise the Commission in terms of the electoral events, electoral calendar, and electoral dispute management. And in fact, of course, in the future, relating to boundaries. And that's what my job description deals. In the time I have served at the Interim Independent Electoral Commission, I'm proud to say that I was part of the team that delivered a successful referendum and restored public confidence in election management in Kenya. I have had the privilege of serving with a great team at the Interim Independent Electoral Commission. I have had to learn new ground because, as you know, that all of us, when we joined the Electoral Commission, none of us had experience in election management. But like all my team members at the Electoral Commission, we all have a teachable spirit. We learned the ropes of the job and were able to work efficiently, and I was mostly in charge of the synergy that went with it. Got all the services to be able to work and be able to synchronize each of their activities. In my previous position, before the current position that I hold, I was editor and Chief Executive Officer of the National Council for Law Reporting. The National Council for Law Reporting is a semi-autonomous state corporation charged with the mandate of publication and preparation of the official Kenya law reports. And that's all judgments of the Superior Courts of Record. I had the pleasure to serve under the tutelage of the Honorable Attorney General and some of the judges here. And in my time there, I can say that I was able to break new ground. As is known, there had been no law reports. At the time of my appointment, there had been no law reports in Kenya for 20 years. We were in arrears in 20 years. It was at a time where it was difficult for members of the bench to have any precedents that they could go back or to quickly access them and be able to evaluate them. And you can imagine that in a common law country without law reports, it's fundamental to the entire system of law. Law reports is fundamental to any common law system, and therefore it was extremely necessary that law reports were undertaken. At the time when I was appointed, although the National Council for Law Reporting Act had been passed, and I must say, the leadership of the Attorney General, after 20 years, it was realized that it was necessary to have a law reporting body. I was appointed, and I then had to set up the institution from startup to a fully functioning organization with full human resource capacity, funding, budget, and strategic plans, and so on. I pride myself in saying that I left behind there an institution that had systems. I remember when I was leaving the I was leaving the Kenya Law Reports, the then Chief Justice told me, won't the place collapse if you leave? And I said, no, I have built an institution. It's not based on personalities. It's the systems that I have built over time, and I can confirm today that they have never missed a beat since I left, because I did build an institution. In fact, they won the TIGA Award, which is the Technology in Government Award, based on the work that we undertook at the time there. And the team did in their speech mention that, thank you for holding our hand throughout the process. We made the 100 last-minute dash at the end. But again, I said I left an institution that could undertake that 100-meter dash at the end of the program, and I'm proud to say that. Also, of most importance is that during my tenure at the Kenya Law Reports, most of the work that we undertook were directly linked to the judiciary. Most of the services that we undertook assisted the judiciary more than any other institution, and that is why it's a state corporation that operates under the judiciary. And so, under my leadership, several programs were started. The most significant being that although my mandate at the time was to produce hard copy law reports, I was able to then convince my board to allow us to be able to undertake electronic publication of the Kenya law reports. It was unprecedented. No one envisaged it to happen, but I'm grateful that when I submitted it to the board, they said, you can do it, but we don't have the money. And I at that time said to them, if you give me the approval, I will find the money. And therefore, that's another skill I have. I can mobilize resources. I'm a fundraiser, and I can set up programs and proposals to raise money for any project that that the organization that I'm working for requires. We also were able to, upon finishing the production of the Kenya law reports and putting them online, and by the time, in fact, 5 years ago, by the time I had been there for about 4 years, we were able to post judgments in a record time of within 36 hours of delivery. Judgments will be posted up on the website. And the team at the Kenya Law Reports, again, because it was from startup, I was involved in the recruiting the human resources there, training them, and which was not easy because sometimes we had to look for lawyers we needed lawyers who had IT knowledge, and sometimes we convinced some of the members in the team to go in and attack that kind of training. Secondly, upon finishing, completing databasing all the judgments ever delivered in Kenya since independence, we began to get calls from various members of the bench, and I'm grateful to members of the bench because they prompted some of our reform programs at the National Council for Law Reporting. They said, but we can now search all statutes, we can search all judgments, but we are not able to search the corresponding statutes because all the statutes were in hard copy. I do remember that at the time, again, we sought the authority of the then Chief Justice and the Attorney General, who gave us the authority to produce the laws of Kenya and digitize the laws of Kenya and post them online. In fact, the only time in the history of Kenya where the power of revision of the laws of Kenya, which is vested in the Attorney General, was delegated to another body, was when the Attorney General delegated it to the National Council for Law Reporting. The third thing that we did at the Kenya Law Reports, which was also landmark in terms of promoting reform within the justice sector, was the publication of the Kenya Law Review. This is a scholarly, it is a book of scholarly, it's a publication of scholarly materials where various academics and people in other fields of law research into the law, mostly the judgments. That is a way of building and developing our jurisprudence. We were also able to undertake another project, which is digitizing the Kenya Gazette. We were able to do that, digitizing the Kenya Gazette from 1900 to date. I remember at the time, my board was worried, and they said, "Why would you want to do the Kenya do this?" And we said because under the law we were allowed to undertake publication of the law reports and other connected purposes, and based on that we were able to proceed. And today, I'm proud to say that all the Kenya Gazette, the entire Kenya Gazette from 1900 to date is available online for free to the public. Hence the reason why Kenya Law Reports won the TIGA Award, the Technology in Government of Africa Award. We were also able, and with time, because we had a huge database of information, the legislation, judgments online, we had also begun to link ourselves with other legal information institutes, and we had this huge database. And most of the time, many judges and magistrates would call and ask, "Can you find for me precedents on this point?" And I'd say, "We'll look for it, we'll get back to you." After a while, we realized it was necessary for us to establish what we called a bench research hotline. That bench research hotline was a fully fledged department that fielded calls from judges where they would say, "I want all authorities on this point." Sometimes, most of the time, the judges knew the magistrates also knew that there was a decision that had been made in the past in Nakuru relating to this point, but they couldn't quite find it. And so based on that information, because we had a very vibrant search engine, we could search it, find it, copy it and send it to them. It became an extremely successful, and I know that when we undertook a survey of the program, at some point we got very good response and an extremely high score from members of the bench, where many of them said that the fact that they could have access to precedents quickly and when they needed it, and very specifically, they were able to cut down the amount of time they took to write their judgments, and also that they felt that the quality of their judgments had in fact improved. At the time, our dream, and I hope that is still the dream of the current team, and I believe so, is that when the judiciary will then have researchers assigned to every judge, it's not enough to hire researchers. You've got to have, those researchers have to have a database or a resource base where they can get the information. And that is what we hoped at in the larger long term, that is what will be achieved with by the Bench Research Hotline. Also, I was instrumental in working towards implementing what they call the Montreal Declaration on Free Access to Law. I was able, working together with the then Chief Justice, who was also chairman of my board, for Kenya to sign the Montreal Declaration on Free Access, and therefore availing. At the time, the World Legal Information Institute wanted us to give them the entire database so that they could put it in the World Legal Information Institute site. And we said, no, we don't want to lose our brand. We do not want to lose control of the content. And therefore, we said we can set up Kenya Legal Information Institute. And based on that, again, the Koya Award that Kenya Law Reports did win was based on that. And I'm proud to say that is something that has been extremely successful also, and put Kenya in the world map. In fact, a few years ago, we were voted as the Kenya Law Reports. I still believe I'm there because, of course, it's my baby. But the Kenya Law Reports was ranked as at that time, it was during my tenure, as being the best in local content. Also, I know that in the World Bank report, and I think it was reported in Success Stories in Africa, I was mentioned specifically as having, for my leadership initiatives in undertaking projects that touched on reform within the justice sector. I also did, one of the other projects that we undertook was to work together with the Parliament on coming up with a formula for databasing information and using open source software, which then cuts the cost, because at Kenya Law Reports we had very little resources, and therefore we were able to say, how do we get a maximum impact with minimum resources? And we were able to develop software that was on the platform on which all our work was running was not commercial software, it was open source software. And lastly, one of the other work that I'm proud of having been part of during my tenure at Kenya Law Reports is development of the digital audio recording system, which was on pilot at the Chief Magistrates Court. And that was tested and piloted, and a report submitted to the Judiciary ICT Committee. We also developed a prototype of a case tracking system in the Family Division and in the Eldoret Magistrates Court. We wanted to get a feel of how it is at the High Court and a different level at the Magistrates Court. The program is ongoing. I know it was launched very recently, but it's a program that started during my tenure. I was very proud to see that it has been said to be the most successful case tracking system within the judiciary. In fact, I know that the Chief Justice of Seychelles did contact me and asked that if the Kenya Law Reports team could help them set up a similar system in the Seychelles. I know that Uganda want to benchmark on the same process. I know that the Malawi courts also wanted to use that as the same prototype, and therefore I'm very optimistic that most of the programs that we began, and I'd like to say this, all these programs were developed by Kenyans. We have the human resource capacity in this country to do it. by very young people. I think at one point, those who used to come to our office, most people were under 25. It was amazing. And so I'm very optimistic that this will be able to move, and to know that it's a Kenyan product, that it's not some commercial software that we bought from the big firms, that it is a resource base that exists in this country. And based on that, I know that I did offer advice to the Ghana. And based on that, I have a very good relationship with the Ghanaian Chief Justice in Malawi, Liberia, Botswana, and the Uganda Commercial Court. And so Kenya is a standard on each of those issues. And shortly before I joined the Kenya Law Reports, I also did teach at the University of Nairobi, and therefore I have had my stint as an academic, as a lecturer. I served with distinction. You will see with my documentation that I received a commendation from the Vice Chancellor of the university for my work in introducing not introducing, but learning and participating in 2 areas. One was the teaching of trial advocacy. I had the privilege of working on that and training under the tutelage of a senior American professor, and attended the National Institute on Trial Advocacy on teaching the art of winning. And secondly, I also was acted as the team coach at the university of what they call the moot court competition, which is like the World Cup for legal students. And they would appear before a mock ICJ, a mock ICC, a mock African Court of Justice on Human Rights. And I'm proud to say that during my time, my team won the African World Cup Championships 5 times. And for the World Championship, we were able to move from first time being ranked 100 in the world, which is a big deal in the JSAP moot court because it's the most prestigious moot court competition in the world. And then we moved to 8, and 4 of my students received the judges' commendation. And many of them got scholarships to do their doctorates. They worked for World Trade Organization, and I do know that I have successful, great students, brilliant out there that worked with me. I also had brief stints I also practiced law at the beginning of my career and worked for the United Nations Environment Program as an international waters consultant. I'm trying to take not too much time. I don't know if that covers it. It covers it.
It does.
Thank you.
Thank you. That is quite comprehensive. You know that under the Constitution, the Deputy Chief Justice is also the Vice President of the Supreme Court. What experiences have you had in court and which you think would assist in making you a good Deputy Chief Justice and Vice President of the Supreme Court?
Thank you for that question. You know, it's the $1 million question. What I can say is that I think I have the experience that I've gathered over the years, which is diverse experience across the entire sector. And I see the position of Deputy Chief Justice as twofold. One, because this is a reform position, undertaking reforms, and secondly, sitting in the Supreme Court as a Vice President. I can say that I probably can say without fear of contradiction that I have been able to get the opportunity to learn. Remember that my job as editor of the Kenya Law Reports, I was reviewing all the judgments of all the judges from, for the last, I have 27 volumes of the Kenya Law Reports to my name as editor, and therefore I had an opportunity to review all those judgments. I understand judgment writing, I understand the jurisprudence of each and every judge. I can almost tell you who is a liberal, who is strict interpretation of the law. I can even, and as I read through the judgments, I also had opportunity to interact with judges, because sometimes in editing, we couldn't quite understand what the judgment meant, and sometimes speaking to the judges, I learned so much. And therefore, I always say, if a judge has 10 years experience in writing judgments, I have 10 years experience of that particular judge. But if there are 50 judges, I have 10 years times 50 years. I mean 50 judges, and therefore I feel that I had a great opportunity. I can think of no other learning ground in judgment writing and development in jurisprudence than what I had as the editor of the Kenya Law Reports, and I think it was an extremely privileged position and the most important learning process. Secondly, I believe that the biggest task ahead of the Supreme Court will be development of jurisprudence. I believe that development of jurisprudence is not something that will be done by one person alone. The Chief Justice cannot do it alone. The Deputy Chief Justice cannot do it alone. It is actually a development has to be the entire sector. It will require that scholars write and analyze the laws and criticize them in order to improve them. They also create from their writings and scholarly articles, they can create a base from which any member of the bench can read that material and be able to help them distinguish cases and improve their judgment writing. I also believe that the lawyers have a great role in playing in this, because if we have to have good jurisprudence, the good jurisprudence also depends on lawyers presenting cases and issues before the court that require settlement by the court. They also have to have undertaken very good research in order to give the member of the bench a wide breadth from which to be able to write a good judgment. I also believe that it's also the entire society in the way that we work. I look at even the role of the National Council for Law Reporting. If they can post all judgments online, if they can avail them, if they can subject index them, if they can produce materials which members of the bench can read, believe me, the quality of judgments shall develop and our jurisprudence shall develop. I know that sometimes as editor of the Kenya Law Reports I was told, that is not a very good judgment, why did you post it on the Kenya Law Report? And I would say, sometimes it's good it's for exactly that reason that judgment is in the law report, so that it gives people an opportunity to criticize it. It also allows another person to distinguish it or overrule it, because if it's hidden under the table, it will always be a bad precedent that will haunt us one day. And therefore, for me, that entire, I think that experience in knowing how jurisprudence needs to be developed is what can give me the upper hand in terms of serving at the Supreme Court. As the Supreme Court. Also, I believe that the position of the Deputy Chief Justice is a reform position. When I look at other countries like Canada, Australia, you can see that apart from being Vice President of the Supreme Court, the Deputy Chief Justice also undertakes is given a certain portfolio. I know that the job description is yet to be written, but when you look at it, they deal with assessment of statistical data, which can allow the creation of strategic objectives around reform at the judiciary. They normally deal with reform issues. They also deal with issues of case management. And again, that for which I have experience, and therefore I am confident that I will be able to discharge the duties of the position of Deputy Chief Justice if I am honored to serve in that position.
Thank you very much. You've answered my questions a lot more than I would have expected, but what then do you consider as your singular most important talent that you bring to this office today?
I think what I would say I bring is I have a sharp legal academic mind because of the work that I've passed before. The fact that I have a balcony view of the judicial system, that I have been able to be an insider yet an outsider, that I have been able to have the privilege of working with judges and magistrates. I do remember, and I think during your tenure and that of Honorable Emily Ominde in the Kenya Magistrates and Judges Association, I saw that I worked and participated as you developed the peer review program, the balance scorecard, the court user committees, and the dialogue card. And I do remember thinking, this is amazing. And so for me, being at Kenya Law Reports allowed me access to know that these programs are going on and to work and be part of those challenges. And therefore, I believe that I have a great understanding of the judiciary. I also know that from within the work that I was doing within my mandate, my power, and my abilities, and the resources that I had at the time, I was able to undertake so many programs that promoted judicial reform. And so, of course, when I think today, when the new constitution came and I said, you know, if I was able to do this much at that time, within such a small mandate in a not very senior position maybe, it's amazing what I can do if I was the Deputy Chief Justice. I do believe that genuinely I'm a hard worker. I work, and I think I began to understand the challenges facing the judiciary more than anyone. I know that when I joined the judiciary, the Kenya Law Reports, I almost criticized the way the judiciary ran. But the more I sat there, I began to understand. And that's why when you see the bench research hotline, I clearly understood the challenges facing the judicial officers. When I did the case track program, I clearly understood the challenges facing the judiciary. When we undertook the putting judgments online, I clearly understood the challenges. It's because of I understood those challenges and did whatever I could within my power and mandate at the time to do that work. And I think that gives me an opportunity to be able to I understand the industry. Actually, I'm not going to be completely new within the judiciary. I've also had occasion to serve in the Judiciary ICT Committee. I have we undertook a lot of research for the Expeditious Disposal Committee. And also in my work, because the Kenya Law Reports was also deemed like a research base for the judiciary. So whenever there was work, and we've seen there is so much that has been written about the problems bedeviling the judiciary. We've had the Kotut report, we've had the Ringera report, we've had the Kwach report, we've had the 2 strategic plans, we have had the ICJ reports, the reports from the Commonwealth panel of eminent judges. All those reports, I had the opportunity to study them. And I can almost say that it will take me a very brief time to come up with a master plan. And because I had, and especially these ideas have come from working with members within the judiciary, not looking at it from outside. So I have both an insider view and a balcony view.
Thank you. I know that you're in the committee which I chaired that operationalized the Open Day.
Yes.
Would you like to say something about the Open Day and whether you think it's still a viable program to run into the new judiciary?
Oh yes, and that's why sometimes I talk and I forget that. That is, I think also that is one of the committees that I served in, the Judiciary Open Day under the chairmanship of Justice Lenaola. Again, that was amazing. It was an eye-opener, and I think you'll agree with me. For the first time, the judiciary opened its doors to the public. We were able to listen to the public and find out what is wrong. What is it you'd like done? And you'll be amazed that what the members of the public say about the judiciary are the same ones that we have in our reports done by the top brains in this country. There is no difference. They understand. Local mwananchi today, if you walk on the street, will tell you, kesi inachukua muda kubwa. They know that. They can tell quickly. They are telling you the wheels of justice are too slow. They will tell you that they don't understand the process. But yet again, and it's easy for them to tell you there's backlog. They'll say, I couldn't get a hearing date, you know. So any mwananchi, walk on the street and ask them, they'll tell you what's wrong with the judiciary. They understand it as anybody else. And therefore, because the judiciary had not sat in a situation where they were talking to the common mwananchi, who then, the Wanjiku was to speak, without it being predetermined and giving them, it was informal. There was, I know the Kenya Judges and Magistrates Association did produce questionnaires which were used at the time. There were people sitting at various booths discussing with people. All that was recorded. And under your chairmanship, the chairmanship of Justice Lenaola, I do remember that we came up with very good feedback from the public. And it was amazing that the public actually know the solutions. I still believe that that is something the judiciary must carry forward. And that's why we were able to undertake it 2 years after that. There was another Judiciary Open Day. We need to build on those kind of successes. I see that there has been, but sometimes we almost lose momentum, but we've got to make sure that we don't lose momentum. And therefore, I have been able to see great initiatives within the judiciary that just needed some form of leadership to harness that and make sure that it doesn't stop and develop action plans. In fact, the judiciary, they know more than anyone else exactly what to do. All they need is an action plan on those things of what to do. I know that Commissioner Ahmed Nasir, in his many writings, one of them which I remember very clearly, he said, no country has shown the kind of collective zeal and devotion that Kenya has shown towards judicial reform. And I believe that. And that collective zeal and devotion does not exist just only within the judiciary. It exists inside and outside the judiciary. Unfortunately, that zeal that is produced in recommendations of what you do has never been reduced to to an action plan. That's where my strength is. I'm an action, results-oriented person, and I can confidently say that action is my middle name. I can actually move to the next action plan and be able to move forward. I was happy to see that the OUCO report, which sort of summarizes, in fact, it just goes back to all the other reports, and the recommendations are actually a consolidation of all the recommendations that are made in the past. One just needs to develop an action plan based on that, and produce a rapid results initiative, which I think Commissioner Chairman Gatere is very familiar with. That was an initiative within the public service to improve service delivery. It is possible. You can do it. You get rapid results, then public confidence begins to grow, and then thereafter you can develop a long-term plan on what you should do in order to have a sustainable reform and improved process within the judiciary. And even as I mentioned about the rapid results initiative, which I think would be the most important thing to do as soon as the reform process starts, is that if in terms of looking at, when I see some of the challenges that were set out in all these reports, actually what you're seeing, what we see and the public see are symptoms of a larger problem. I would believe that if I were appointed Deputy Chief Justice, I would immediately grind backwards and ask myself and work with everybody within the judiciary and say, what causes this problem? When people say that they don't have public trust in the judiciary, that is only a symptom. You ask yourself, what caused that lack of public trust? Is it bad judgments? Is it the slow pace of justice? If it is that, says, what causes the slow pace of justice? If the slow pace of justice, you go back, you may find that it's a lack of use of technology, poor staffing, low morale within the judiciary, and so on. And therefore, we need to now step back and say what caused it and be able to resolve it. And the answers are out there. One would not have to be a rocket scientist to figure it out. It has been done. It is available. We just need to move to an action plan.
Thank you very much, Mrs. Shollei. Mr. Chairman, that is it for me.
Thank you very much. Commissioner Mwangangi. For that, maybe the Attorney General would like to make a comment.
Thank you very much. On a light note.
Yes.
Light note. You say that action is your middle name.
Yes.
Not boss.
Both.
Both.
Yes. In the workplace, action is my middle name.
Okay.
Yes. And you do know that,
I know.
Attorney General.
Yeah. I think nobody can doubt, at least speaking for myself, you are a high flyer in the area of administration, and particularly in the area of IT, as it applies to the various areas that you wanted to apply, and in this case, law reporting, and also, digitizing the laws of Kenya, and many other areas, where, of course, you have set modules which are now going to be used in other African countries. So, to me, there's no doubt there. You have made your very invaluable contribution, and also academically, in administration, stands out. Leadership seminars at Harvard, elsewhere, I think stands out, and so on. But coming now to the job of the Deputy Chief Justice, you have made a comment that you edited all the judgments, and therefore you may be, very well you may be the only person who knows who are the level of judges, who knows the content of those judgments, and so on, and therefore really knows our judgment very well. And I would like to know, because of that knowledge, and particularly judgments which had hitherto not been reported for a period of over 20 years, but you, by virtue of the fact that you are the editor, now became aware of them, and you read them and so on. And I believe these are the judgments from around 1978 there up to for the next 20 years or so. In that period, I want just broad answer. You'll be asked issues on judgments in detail by another commissioner, but to me it's just broad. What would you regard as the landmark judgments? Maybe you can give us 2 or 3. Whom would you regard as the best judge in terms of writing judgments? And whom would you regard as that judgment that must be reported so that they may be either distinguished or overruled? Yeah, you can give us examples of those type.
Thank you, Mr. Attorney General, sir, and thank you for the compliments too. Just that I will speak to that generally. I will not be able to say which was a bad judgment or a good judgment, because I know that one of the things that I introduced at Kenya Law Reports was signing of confidentiality contracts so that none of our officers could write publications criticizing judgments. We simply stuck to reporting and notified Kenya Law Reform Commission if it was necessary, if it was areas that required reform. Sometimes contacted judges when it was, sometimes when a decision was made on a repealed law, then we privately contacted the judges and they would deal with it. And that was actually what, because we felt that we were in a trust position. But if I talk of the more recent ones, I think, and I think one of the judgments that stands out, and I can say because it's a positive remark, is the Ringera judgment, the one on Joya, on the Constitution. I know that that was a very good judgment, and we were able to forward it to the Commonwealth Law Reports, which was also published in the Commonwealth. I think it's the only judgment relating to participations by people in their participation by people in a new constitution within the entire Commonwealth. That was an area, for me, the ones I'd look at were the ones that touched on areas that didn't exist anywhere. I do know that there was also the one on that drew inspiration from the CEDAW, from the Convention on Elimination of Discrimination Against Women. And it was, I can't remember exactly which judge, but there were judges who made, and they were not just one, there were about 3. And I do know that this was actually a direct result of the Jurisprudence for Equality program, I think, which is done under the Kenya Women Judges Association and the Kenya Magistrates and Judges Association, where they are trained on that. And it was that particular one I remember because as a result of that, they were able to interpret the law in such a way to say that it is discrimination to actually not allow girls to inherit property from their fathers. And I know that we did, of course, I've been away from Kenya Reports for about 1.5 years, but I know that there is a publication that we produced, an in-house publication under my editorship again, that actually went over landmark cases. Some of them were even cases where the courts lost the opportunity to restate the law when we had all been waiting, because we used to wait sometimes for certain cases and say they are finally going to settle this matter, and sometimes the opportunity passed and we would be like, oh no, that shouldn't have happened. So there were those kind of judgments. There were also judgments where we were waiting for the courts to redefine an issue, and we knew that that issue was a thorny one, because we would get a lot of requests asking for certain precedents, and sometimes we tell them there is this, but it's not fully settled. This especially came from the magistracy, where they needed access to precedents, and they were not able. Sometimes we would give them access, but they would have like 4 or 5 judgments that they want, which really were conflicting, and they were not able to decide on what the position was. And I think on account of this, because we wanted to be able to avail them all the judgments, was we did produce the bench bulletin, which was a summary of all cases that had happened in the court in quarterly every 3 months, and that really was targeted at the magistracy, who then, so that magistrate in Garissa was able to know what has happened at the Court of Appeal and at the High Court in a very short way, in a small newsletter that gives them a summary. And therefore, if they wanted that authority, because they knew now it existed, then they would call us and we would be able to provide for it. So that's the one I can. I think also the Ilchamus case was also an interesting one, the one that talked about representation, and I think the ECK then was one of the parties. Yes. But there is a write-up. Actually, I have a very comprehensive write-up that we did produce at Kenya Law Reports on landmark cases, and maybe one day I'll make sure that it's given to all the members of this panel. It would be very useful reading. Thank you.
Thank you, Chairman. Madam Shollei, I'm going to discuss with you about judgments and rulings, and this is in the light of your application to serve as the Deputy Chief Justice of the Republic of Kenya. And I just want us to start from the point about your knowledge on constitutional issues. I did hear you talk about your experiences with judgments and rulings because of your editing work with the National Council for Law Reporting. Other than that encounter with the judgments and rulings, have you practiced any constitutional law?
No, not in recent times, except when I was briefly in practice. But I have taught it, I have studied it, I have, in fact, written papers on that, and I mean, in terms of researching on those areas of law for purposes of use by the judiciary, yes, I know to do that.
Thank you. So do you understand the role of a Deputy Chief Justice under the new constitutional dispensation?
Yes, I do.
Can you tell us about it?
The Deputy Chief Justice is going to be the deputy head of the judiciary. They will deputize the Chief Justice. They will also serve as Vice President of the Supreme Court when the Chief Justice is not presiding.
What about the role of the Deputy Chief Justice, especially on the side of implementation of the Bill of Rights? What is the role of the Deputy Chief Justice?
Yes, I'm. Like I said, that I've not seen that there is yet a comprehensive, detailed job description of the Deputy Chief Justice. But in other countries where this position has come in anew, or you would find that the Deputy Chief Justice would have certain work that has been assigned to them. So it could be that they are in charge of implementation of the Bill of Rights, implementation of the pace of the implementation of third generation rights, and so on. You were nominated
and actually appointed as Deputy Chief Justice. What would you do about now setting out the roles of the Deputy Chief Justice so that one is sure of what they're supposed to do? What would you do?
Of course, it is best practice in any organization that every position has a clear job description. You do not want a situation where a senior officer is actually waiting to be handed out leftover work by their superior. They must have a clear portfolio, because then they can be able to be measured based on that, on their performance. I think a good example is the Electoral Commission, where I'm serving at the moment. I am the Deputy CEO. The CEO has his portfolio. So I have, out of the 9 directors, 3 directorates report directly to me, and I'm fully in charge of that and report to the Commission on that. The Chief Executive also has his docket, and so it's clearly defined, and therefore we are able to have measurable assessments on what we are required to do. I assume that upon this, because it's things that will be set out either by the Judicial Service Bill, it's called the Judicial Service Bill, and also within the development of the job description. I think that is something that members of the judiciary as a whole, together with the National Council on Administration of Justice, would actually sit down to develop it. I can't say that I'm always shy to be able to say, I think this is how it should be cut out. I think this is a consultative process, especially because I think the great innovation of having the National Council for Administration of Justice is that it got representation from the entire justice sector. It's a lot like the governance, justice, law and order sector that was run under the Ministry of Justice, which I had the privilege of serving as co-convener for the justice sector group and thematic group. And you will see that actually it's important that when you have to sit and speak to all the stakeholders. I think that has since been realized, and hence the reason why it's been incorporated, that all those stakeholders need to sit together in order to develop that. Of course, there are those that are obvious and are within the Constitution, but the detail of it and how it works would have to be something that would be developed as a consultative process.
Thank you. Okay. Now, if you look at a judgment from the time you've had to edit them, and I believe there have been quite a number of them, what would you say are the minimum contents that should be seen on the face of a judgment?
Okay, thank you for that question. Very interesting to me because it's an area that I have constantly studied. I think, in fact, Honorable Ominde and Justice Lanola will remember that we did invite a professor who trains on judgment writing, whom I had met at a different conference, who agreed to come to the Judges Colloquium in Kenya and sat and sort of trained on what are the minimums. But also the minimums are known. It is within the law. I did help him in researching because I veiled to him judgments, which he developed a paper which he presented at the Judges Colloquium, which has since been published in the Kenya Law Review and was a publication and was peer-reviewed actually by members of the bench. I would say that the minimum requirement of what should be in a judgment, it is in statute. It's very clear that the facts must be set out, of course, apart from the titles and all the other, the title, the dates, and so on. What must be there, most importantly, are the facts, must be set out. Also, the issues that have been raised for determination by the parties should also be there, so the issues must be in the judgment. Apart from that, there should then be a decision on each and every issue. And once a decision has been, you've set out the decision on each and every issue separately, then you would then, but remember, in coming up with the decision on each of those issues, you'll come by it by setting out the issue and then applying the law to those facts and to those issues. It's actually like 1 + 1. The facts plus the issue plus the law equals the following decision. And when you have set out that decision, then you would write the reasons for making each of those decisions. In fact, the meaning of a judgment in legal terms is the reasons for a decision. So you actually have to set out. It's a requirement that you have to set out the reasons. It's not enough just to say it. You've got to say the reasons and the applicable law and which law you applied to those facts in order to come up with that decision. The reason why you have to set out the facts is that we don't want to have a situation where we are saying what are exactly the facts to which you applied the law, because the answer will change depending on what the facts are. And that's very important. And I know that at my time in the Kenya Law Reports, I toyed with working with members of the judiciary to produce a tool for judgment making, for judgment writing, because you can actually create a tool which can be used, and that happens in the best corporations, that you have a tool which sets this out, and therefore, although you have the freedom to write the judgment, that you know that these are the bare minimums that must be contained in it. So the law is very clear on what a good judgment will entail. I also think that in writing your reasons, it's very important to be persuasive. You can only be persuasive also if you have a high command of language. You also have to ensure that the judgment does not contain any biases. That is almost, I do know that at some point the Court of Appeal actually set aside a decision on patent bias, because when I looked at the judgment, it was sound in law, but the judge had written in such a way that their bias are so obvious and clear that and I thought it was an interesting concept, patent bias. I think it's also important that the judgment is written with decorum. That I did see judgments where a court would say, this judgment could not even have been written by a magistrate. First, it's condescending of the magistracy, whom I think do very noble work, and 90% of justice is served at the magistracy. And so it's not a good thing to say. Also, it's also condescending of the judge who wrote that. I think it's important to clearly state where the judge erred, whether in law or in fact. I think that's important. So it's the language, the way that you present it. Judgments must also be written in such a way that there is no ambiguity. And I also am a strong believer in neutrality of judgments, but I guess a question of style, which can also be debated by members of the judiciary and agree. Neutrality means I will not say he or she. I will not mention that I saw a lot of judges that said counsel for the defendant, said the following, and so on. You find that in other places, and that's why I say judgment, right? Those issues that I'm raising now are not the ones within the law, but it's a matter of style which members of the judiciary can. In other judiciaries, they sit together and come up that we say, do we agree on a neutrality principle? If the answer is yes, then they would do it, and they would then write in such a way that you refer to the issues as opposed to the litigants, as to the counsel. Avoid too much of copy and pasting what exactly, unless where necessary, they can agree on the middle ground on that. But again, those are not issues really that for me to say. It is a matter of opinion, but also depends on the jurisdiction of that country and what the members of the bench think that it should be. But I think things like decorum and not being condescending are really absolutes that I think one cannot degenerate from.
Thank you very much. You answered a number of my questions actually before I asked them, but anyway, it's all right. Now, let's talk about your experience still on looking at these judgments and editing them, and what you have just told us, the qualities, the decorum, the simplicity in the language, no ambiguity, and so on. Did you notice most of the judgments meeting these standards as you were editing them?
Yes, I would say at least 50%. Yeah, in terms of meeting that particular standard. I came across good judgments. I came across bad judgments. I also realized it was a question of style, and the style was as many as the number of judicial officers. I mean, there were judicial officers who wrote good judgments, very brief and concise, because I think, and you'd find that they're usually the ones who would complete more work. And at the end of the day, sometimes it's a matter of the rationale, and you say, sometimes the public just want a decision. You know, the great writing is actually for academics. People like me enjoy that. But when you think of it, the public just want a conclusion on the matter. So sometimes I think a member of the bench would decide, you know, do I take longer and not decide the case quickly, or should I? And so it was an issue of balancing. But again, those are some of the things that I think we require a forum for members of the judiciary to discuss and say, where should be the middle ground? What should we do? In what circumstances? But I can see that sort of coming, because I've seen with the civil procedure, the new civil procedure rules, they indicate that there'll be some cases ranked small claims, fast track, multi-track, which means it's complex. You see, I've been too long out of the judiciary. I need to get back. So multi-track, and what happens with that is that I believe that once they've produced that, they will probably also, based on that, say, for small claims, these are the bare minimums you should have in the judgment. Because small claims, you want to finish them quickly. The parties usually are people without too much money, so you want to make that speedier for them. For the complex ones, it can be that people can take more time on that. So I think that is the starting point. The civil procedural rules will be a starting point on deciding, and them coming up with a consensus on how the judgments should be written.
Thank you very much. Let's talk about now the quality of the judgments. And I have in mind the issue of building jurisprudence, because a judgment should not just serve the parties at that particular moment, but there should be a basis for building jurisprudence and, as a matter of fact, developing the law. Now, when you've applied to become a Deputy Chief Justice of the Republic of Kenya, you appreciate that you're going to be the Deputy President of the Supreme Court. You're also going to sit in that Supreme Court, and it has the role of setting precedents, settling the gray areas in our laws, and, as it were, setting an example to be followed by the other courts below that court. Now, from your experience, what would you say you'd bring into that particular court, the Supreme Court, for purposes of building jurisprudence and developing the law?
I think what I would bring, again, as I said, I understand what it takes to develop jurisprudence. Getting the entire sector work and channel their time and energy towards improving jurisprudence, stimulating debate and discussions on various aspects of the law, making those judgments available. Also, when you look at jurisdictions that come up with have great judgments, it's where actually the parties are required to give written submissions where they say, these are the facts of my case, these are the issues, this is the law that I'm pleading should be applicable to it, and these are the supporting authorities. Actually, when the lawyers submit that to the court, it makes it so much easier for a member of the bench to come up with an earth-shaking judgment. So for me, I understand the process, because it's not one-off decisions when somebody gets a great inspiration. It's about a system that fosters that kind of generation of good judgments. I must also say that the fact that you've been sitting a long time on the bench does not necessarily, I think, and it has been shown by, and I have one example, that does not necessarily mean that you will come up with a great judgment. I know that Al Warren was, I think, the 14th Chief Justice of the United States. He had never served as a member of the judiciary, had never served as a member of the bench at all, but he was sat on the court that pronounced the Brown versus School Board, famous case. It was still his same court that came up with the Miranda case, the Miranda principles, anything you say shall be held, and so on. I mean, so when you think about it is that, but what he brought to that court, and I think he was rated as, I think, one of the greatest Chief Justices in the 20th century, when you look what his contribution really came from him having a diverse experience across the sector. He even served as a politician. He was a vice president and presidential nominee. He served as a district attorney. He served as a governor, and so on. So for me, I believe that really, if you have a great grasp of the law, you can analyze facts, you can set out the issues clearly, you have a sharp understanding of the law, that you think through and you're diligent and work extremely hard, I think, depending on the case before you today, you can be able to make a great judgment. I do believe that I have the capacity to do that. Bring a case before me, if I apply that and all the knowledge that I have using that kind of formula and understanding, you can write a good judgment. You can't say in advance, I can write a good judgment. The facts have to be brought before you, and certain things must work in the system also to foster that. A judge who has 20 cases to hear a day, how is it that they're going to write a great judgment? They're basically a conveyor belt. They're trying to. So the system has to also support you. In countries where have had, we say they have great jurisprudence, if you look at the ratio of judges to the population, is very low. I think Canada has 107 per million. I think 47 for Australia, 50 for them. Kenya has, I think 10.5. I think the last time I undertook that research, which is maybe 2 years ago. Think to yourself, and we have seen there is a direct relationship between the workload that a judicial officer has and the output that they produce. We must, so we cannot say it can be cured by having an extremely brilliant person on the bench. You put a brilliant person on the bench, you overwork them, you put 20 cases before them, they work under the most stringent, difficult conditions, they have no support services, they do not have researchers, they don't have resource materials. Believe me, they will not be able to write a good judgment. So for me, I'm a strong believer in that it's a system issue. It is not individuals. Yeah.
Thank you very much. Now, let's talk about access to the law. And I'm thinking about written judgments and rulings. And from your experience, we could talk of law reporting here in Nairobi, maybe a few other big towns in Kenya. What would you do as a Deputy Chief Justice to make sure that the mwananchi at the farthest end of Kenya is able to get this law as has been decided in a particular judgment or in a particular ruling? And of course, so that they are able to know with certainty if they're going to have a similar issue and they go to court, what is likely to be the judgment, okay, in their case, in view of what is already stated. How are you going to make this access to law possible to the farthest end in Kenya?
Okay. Thank you for that question, because it is one that I hold dear to my heart. And you will see that during my tenure at the Kenya Law Reports, we began to produce the bench bulletin. The bench bulletin is a small material that has case summaries of cases that have happened and which we would circulate. In fact, we were able to fundraise such that we were able to give out those the bench bulletin for free. But at that time, we were targeting the judicial officers, mostly the magistracy, because especially those not in the city, because the ones in the city have access to certain information. But those are outside. And remember that it was during my tenure that Kenya Law Report signed the Montreal Declaration on Free Access to Law. I'm a strong believer that people we must demystify the law. People should have access to it. And I think that was the theme of the Judiciary Open Day under the chairmanship of Justice Lenawala, that it was demystifying the judiciary, allowing people to access it. And I believe that if we are able to, I'm a strong believer that the law must not be sold. Judgments must not be sold. I believe that it is a service that the country must provide to the public in order to make sure that people don't resort to self-help. People have to have confidence in the judicial system. So in terms of accessing the parliament, I believe that if you have given it available to let's say, the lawyers and so on, what happens is it has a trigger effect. It means that all the non-governmental organizations and organizations that are involved in legal aid and advice and support to people in the grassroots level have access to it for free, which means they can disseminate it. Of course, we need to encourage a culture of this kind of education. Something powerful that I learned at the Electoral Commission is voter education. When you think of it, it is the constitutional responsibility of the Electoral Commission to educate voters. I think it is it should be the constitutional responsibility of the judiciary to educate the public. They must undertake, they must have a directorate of voter education. I mean, not voter education, of legal education, or the basic level, so that people know, what do I expect when I go to court? What are the bare minimums? Like the litigants charter, yes, was produced, very commendable effort within the judiciary, but again, disseminating that in a simplified format. And I think we did find that during the Judiciary Open Day questionnaires, that people said, yes, it's been out there, but it's not in the right language, we can't understand it. You can get these community-based organizations out there, and I think I can see Professor Mangu, because she understands that this perfectly, that if you have community-based organizations, because the way the voter education program works at the Independent Electoral Commission is that we then recruit voter educators. We recruit service providers who then train voter educators at the level of community-based organizations, church groups, women's groups, small business communities within the market. If you educate them, believe me, they educate another group, and before you know it, you will have an extremely knowledgeable society. This, I have seen it work, and when I was at the judiciary, I did not know about this. It's something that I've since learned, and I would have recommended that time when I was still there, because we even got to training voter educators at the ward level, and the ward level is the smallest unit. If you can actually, even just 2 people at the ward level, at strategic place, you go to a ward and you say, in this ward we would assess and ask ourselves, where is the big target, where is the place that most people meet? It could be a mosque, depending on the area of Kenya, it could be a church, it could be a market if it's a very vibrant business community. You train those, and their job is to keep retraining. They move from one place to the other, and the knowledge base of people improves. That's exactly how the Electoral Commission was able to achieve a 71% turnout. It's unprecedented and has never happened in any other way, even in the most mature democracies. So that education, I believe that in order to reach the people, we must have a clear, concerted legal education campaign to the Mwananchi, to the Wanjikus, not the lawyers. The lawyers already know it all. People at a certain level, they know it. Where we have a problem, because sometimes somebody says, I went to court and kesi yangu haikusikizwa, and you ask them, and when you look deep to it, you realize it was adjourned at the request of one of the parties. The unrepresented party didn't realize that there's something called an adjournment. They need to understand that. They don't even know that there's something called a cause list, so they can be able to go to their cases. Even people accessing the information. I think if you see what the judiciary has put in place now, the SMS system, the query system, where you can find if your case is coming or they can send you an SMS. I must say that I participated in the ICT committee at that time. I did visit Ethiopia, where the system was being run, and thereafter managed to again go a second time with the then Chief Justice, and that is from there is when he came and established the ICT committee. And when we looked at it at that time, is that although Ethiopia was it's a smaller economy, higher literacy level than Kenya, but yet you could find that but we know everyone, even Mama Mboga has a telephone. If you're able to communicate with them certain critical information, they will begin to see the judiciary in a different light. They're not going to worry that they've come 100 kilometers only for their case not to be heard. I think that's important. We've got to have a culture where, because I think the face of the judiciary out there is really the magistracy. And so you find that it is important that those magistrates be also charged with the responsibility of that legal information education, that they would chair and be able to get involved in explaining the information. And so even just that kind of sending the information, but it has to be a concerted campaign. It's probably going to be a 10-year plan, but we've got to start doing it now, because as long as we operate the law at such a high level that nobody understands, you're very right, access of the law will always be mysterious and only for a certain top class of people, which is unfortunate because the law applies to everybody.
Thank you very much. I get you on that. I've got just a few more questions to go. From the time you've been editing judgments and rulings, because I guess that is how close it came to judgments and rulings,
yes.
Did you have the experience of backlog of cases? Did you have the experience of delays in the delivery of judgments and rulings, particularly as they are rolled out from the court?
Oh, yes.
And if you did, and assuming that you become the Deputy Chief Justice, what plans have you to deal with this particular issue? And again, I want you to give us two-faceted answer, the short term and in the long term. Because we know we are operating, of course, under difficulties, especially budgetary allocations. We may not have all that money to make sure that we have all that you'd want us to have within a very short while so that we stop delays in judgments and rulings delivery. How can we address this issue in the short term, of course, as we plan for the long term?
Okay, first the issue of backlog. Again, the issue is again something I would describe. It's a symptom of a larger problem. The reason why there is backlog, if you grind back just on the top of it and from reports that we've looked at and my experience in the judiciary, was really that you find, again I said, nobody has ever undertaken an audit to say how many cases does a judicial officer hear per day, per week, per month, per year. Based on that, we can go into planning and project what we think we have been receiving, and then you can calculate with precision how many judicial officers you require. It is not enough to say we need 100 judges. Maybe you need 1,000, or maybe you need 10. Again, it's got to do with planning. We've got to go back to the drawing boards. I would like to see a situation where an audit is undertaken so that you are making an informed decision on the number of judicial officers, so that if the backlog is caused by lack of human resources or shortage of human resources at the judicial officer level, then we know that we can treat it and cure it at that stage. If the backlog is caused by the fact that files are missing, cannot be found, let's tell ourselves how best can we make sure we can track these files so they don't go missing. If backlog has got to do with too many cases, I had the occasion to look at many of the cause lists. I would see a cause list of a magistrate has almost 20 cases. I said, it's not humanly possible to hear all those cases. And I did speak to many of them. I said, it's not. But it seems like the control of filling the diary is done at another level. Yet the person who can make a clear assessment of how many cases they can hear is not in charge of taking on new cases. So I would look at that kind. I would want to undertake an audit in order to make an informed. I'm a strong believer in data. When you have data, you're able to look at it. I know that also when I served on at the Judiciary Open Day Committee, again it was the same committee under the chairmanship of the Justice Lenaola, we did find that the one question that recurred throughout was backlog. I mean, my case has not been heard since 2005. My case has not been heard since 2001. Where somebody says, my case has taken 10 years. But when you make a complete assessment, and we did as a committee, you found that the case didn't take 10 years. It has taken 10 hours over a period of 10 years. So that we should ask ourselves, isn't it, and I've seen it I think the civil procedure rules is going to improve this, if properly implemented, because you tell yourself you're able to sit and say how many witnesses are you going to call, for how long, and so on. So that even if you tell someone that you will have to wait for another 1 year or 2 years for your case to be heard, you know that when you start hearing it, you need exactly 10 days, then you need maybe a week break, and then 3 days to prepare the judgment, something like that. So you're able, the planning aspect, and you'll see that the best corporations which I have studied actually have a planning department that their job is to design plans all the time from talking to judicial officers. As you say, how do we deal with that quickly? You mentioned the issue of cost. I believe again in the philosophy of minimum resources, you can have a maximum impact. You do not have to spend so much money to have an impact. If you look at the budget of the Kenya law reports, it was nothing, but we were able to maximize. Yeah, and you have to look at those things that make an immediate impact, which builds confidence in what you're doing, and therefore you get more support. When you do digitization, we use students from university to help us undertake. We collected judgments from all over the country and scanned all Kenya Gazette. What we did is we couldn't set up a fancy system to recruit people because we couldn't afford to recruit them, but we went to the universities and said, we had Jomo Kenyatta University, which had students who required to do some work for free for 9 months in order to get their degree in ICT. We used them. We go to the university and say, we can take them on. We went to the Kenya School of Law and got authority to take pupils. Again, we were able to use them. We went to the law school. Get the students. So it's using very small cost. On the issue of people are impatient and would like, of course, people want to see a result. If I were to say that I do undertake an audit in order to do an audit of the number of cases and so on, in order to deal with the backlog, then I would tell myself, and because people are impatient and I want to see a quick solution, and Kenyans rightly are demanding a quick solution, then you then go back to what I've said is the Rapid Results Initiative. I thought it was a brilliant initiative, because what it does is you're able to isolate and say, this is all I need to do. But what is it that I need to do? It's the word quick wins, really. So you say, in this dealing with the backlog, what can I do that quickly can show some result immediately? And immediately you show some result, people get confidence and there'll be less complaints, and the judiciary begins to earn public trust. During that time when you're enjoying the trust, it allows you to undertake the long-term programs. It's very similar with what we did at the Electoral Commission. We focused on things that we could rapidly have results on, that there are grand plans that we'd like to have done, but because we had a very short time between the time we went into office and delivery of the referendum, you focus on the quick wins. And that way you get the confidence of the people. And once you have the confidence of the people, that's what gives you the blank check to undertake any other long-term reforms in the process. And that is, I think, just a basic suggestion on how to do it.
Thank you very much. Now, finally, I just want to know your view on the principle of stare decisis, and particularly when you're seeking to be the Deputy Chief Justice and, of course, to have the opportunity to sit in the Supreme Court, and knowing that that is the court that is going to, as it were, set precedents in law. I saw some of the papers that you presented about stare decisis, precedent, and so on. And when you were going through judgments and rulings by way of editing them for law reporting, were you comfortable that the highest court in Kenya, as of that time, the Court of Appeal, was following that particular principle? Okay, that's first question. Number two, related to that, did that particular Court of Appeal, in dealing with the cases and having the opportunity to set precedents, did it contribute to your satisfaction to the development of the law in Kenya? Okay? And finally, in its decisions, did you come across any decisions that you felt you were uncomfortable with, knowing that you had the facts on the table, you had the issues, perhaps you even had the research, and you had the other laws relating, the other cases, similar authorities, similar to the issue that was at hand? Were you comfortable with all the decisions that came across, or is there any that struck you as something that if you had the opportunity to sit in the Supreme Court, you may want to recall and look at that particular issue to put the issue of law at rest?
I think the doctrine really of stare decisis is the doctrine of precedent, that if cases of the same facts applying the same law should give the same result. Kenya is a common law system. Like I said at the beginning, as I explained my work at Kenya Law Reports, the principle of stare decisis is the basis upon which it's a very foundation of any common law system. And therefore, and the way in order for this to operate, you cannot have a common law country or a country that applies the doctrine of stare decisis without law reports. It is impossible. It will be running judgments on rumor. And yes, I did come across many judgments that were contradictory, sometimes from the same judicial officers, from the same court. But again, I always looked at it in the context in which they worked. When you say that remember there hadn't been law reports in Kenya for 20 years. The members of the judiciary, of the judicial officers, the members of the bench, had no way of counter-checking any other cases. I understand this perfectly because during my days when I taught at the University of Nairobi, the Faculty of Law, I remember students would write in the unreported case of Kamau versus Kamau, they cook up the facts, they cook up the ratio, and they give you what the decision was. Sometimes you read and say, wow, was there such a decision? But again, you had no way of checking with precision. I think every member of the bench will tell you that lawyers appeared before them and said, there are many authorities on this point, but they never submitted the authorities because there's no law reporting. Again, you may find that a diligent judicial officer wants to work and wants to be able to write a good judgment, but they don't have the benefit of looking at other precedents. They're not available. So when you talk about applying the doctrine of stare decisis, it fully functions on the understanding that those precedents are in fact available, properly analyzed in an easy format for judicial officers to make a quick reference. And that's why the bench research hotline at Kenya Law Reports was trying to help this. That doctrine cannot be as good as the system is. I know that when you looked, I know in many cases you'd find one that where the precedent was not followed. But when you think about it, the judicial officer did not have access to that precedent. They don't know it exists. They're not magicians. They can't find it. And that's why for me, I will always speak about the challenges facing the judiciary with a much softer heart than most people, because I truly understand. I know that I could have had 100 judgments that I knew about, and I can vaguely remember what they were about. But when you create a database, you can search them quick. You remember. The judicial officers never had access to that. So yes, there were conflicting judgments. Some may have been deliberate, but a great majority, I must say, were the fact that they just didn't have access to precedents. You may say that this decision, you should have actually distinguished the law. But how do you distinguish the law if you don't have access to all those precedents so that you can be in an authoritative position to distinguish it? And in my case, I do know, and that's why I'm saying I had a lot of interaction with members of the judiciary, and many times I did find, I even remember one particular case where there was actually a member of the bench, and I try to say this with anonymity because, again, I'm under a confidentiality contract with the National Council for Law Reporting, and it would be disrespectful for me to do so. But you find that the same member of the bench made a decision in a certain way and then sat in another bench, same fact, same law, and the decision goes differently. But on occasion of having discussion with that, because I'd bring it to their attention, and when you looked at it, you actually realized that the one distinguishing feature, they could have been able to pick it out had they just had access to one precedent. So I do understand the constraints and the frustration and the challenges and the difficulty under which judicial officers work. It was even worse for those who worked outside Nairobi. At least those who work within Nairobi. You would also be talking to members of the bar who could access the information. And you can see that this search for have access to precedents. You know that the top law firms constantly purchased copies of each judgment from the courts and tried to compile them. They would hire hundreds of students to try and summarize those for us. And it was from understanding this challenge and this pain and this difficulty that judicial officers go through that I undertook some of the work at Kenya. I would like to build upon that and make sure it's freely accessible. There is nowhere in the world, when we talk about great judgments from all these other jurisdictions, you're not comparing apple for apple, because you cannot compare our judges and our judicial officers with those of those countries. I have had occasion to go to many courts in many other different countries, and you would find that one judge has, at the level of Justice Lanola, would have 9 permanent attorneys assigned, whose job was to search every law, every aspect of jurisprudence, whether within their country or outside their jurisdiction, relating to that matter before them. Wouldn't that judge just produce a brilliant judgment? Yes. So we cannot be unfair to our judicial officers and show them. And I would be trying to, that's why I said I believe in building systems. I believe that we've got to put these processes, because your output can only be as good as your input. And I hope I've answered all your questions. Yes.
Thank you very much, Madam Shollei. Thank you, Chairman.
Thank you very much, Gladys Shollei. I think I will start where the Attorney General left when he said, your CV or resume is impressive in terms of, the jobs, especially in the IT sector, electronic law reporting. But I'm sure you are conscious of the fact that, we are not recruiting for an IT company, like whether it is Siemens or Microsoft. What we are recruiting for is the Judiciary of Kenya, and we are looking for a Chief Justice. Deputy Chief Justice. In other words, your background is excellent, but it's not our core business. I mean, it is a support system. It supports the judiciary in delivering justice to the litigants and making the justice system accessible. But, whether the judgment will be posted to the website in 30 minutes or 1 hour is something good, but that is incidental to the core issues we are looking for. And when I look at your CV, apart from, that good secondary, function we expect or we will provide, I don't find the core issues we are looking for. I don't find the primary attributes we are looking for. And so my questions are, how can, we don't want to gamble with you, I mean, the other candidates, they were a little bit easier. I mean, I could look at their, judgments or everything they're writing. I mean, this is the first time a lawyer who has a background in IT, very strong in IT, wants us to consider her for Deputy Chief Justice. So, I mean, do you think, or, I mean, I don't want to even say, do you think, we want really the substance. Where can we find the substance that in terms of, legal theory, in terms of experience, in terms of, the know-how, and this we need empirical evidence from your CV or from where you work.
Exactly the reason that you are having these interviews today. If the experience and the judicial system as it's operating within just focusing only on primary and development of theory of the law only was sufficient, then we would not have had to have a constitutional issue in terms of developing how to improve it. Like I said, what you are seeing is the problem with the primary business of the judiciary is actually the cause is the secondary function. You require a change. You need to shake up the culture that you have been dealing with in order to say, we've been trying to 30 years and it's not working. Obviously something is wrong. We need to grind backwards, focus on that secondary function and be able to focus on it. Yes, we are not Microsoft, but you definitely know that all the top organizations require Microsoft to function. When you say, when you have delayed judgments, when you have loss of files, when you can't even take stock of how many judgments you have, cases you have pending. It is if you want to solve that, which is your primary business, then you have to use Microsoft and such tools in order to do it. Again, we must say, if we have been sitting on the bench, hearing cases, applying the law, using the same system. We tell ourselves, why is it that it's not right up to today that we're having this discussion? Like I said, not enough, and you yourself did, Commissioner, say that no country in the world has shown the devotion and collective zeal to try and reform its judiciary. What we have been focusing on discussing our problems. We are done discussing our problems, I believe. I think it's about time that we begin to say, how do we take action points? If the action point that requires for us to work is use Microsoft, so be it, we shall use Microsoft. If we are to be able to say that we want to, and we have to put in a case track system, all these are actually the programs that are going to improve the primary business. The secondary business, yes, we must never lose sight of our primary business, and every organization is always remembering. That's why the words co-business and support services and secondary business was coined. But nobody has ever said, let's abandon our secondary business. They have always said, I agree with you, we must not lose sight. I think that's why I agree. We don't lose sight of our primary business. But we will have to employ, whether we like it or not, those secondary functions in order to perfect our primary business. When I talk about developing tools for improved judgment writing, that tool is a secondary business. But writing good judgments is our primary business. So I would say that we would need, the one thing Kenya has not done is try and focus on the secondary business. I have to be able to tell myself, if one will say that the reason why we have, you will get complaints that there's lack of morale, poor performance, and so on. You go back and ask yourself, yes, it's our business to make sure we perform well, but, and we know that the various principles on judicial conduct says that that is not the way that judicial officers should really have excellent high integrity and so on, but we go back and say what is causing it. We must be able to focus on that. So yes, I think it's about time. More than ever in the history of Kenya, we require to look and focus some of our energies on secondary business without losing sight of our primary business.
Thank you very much. I don't agree with you, and I think I don't agree with you very strongly that the reason why we are is because we have not emphasized the secondary aspects. This commission is very conscious of that, and just for your information, we will employ a director for IT for the judiciary so that he can address those issues. But the main reason why the judiciary is where it is because of, incompetence of some judges, corruption, political manipulation of the process, lack of independence, lack of resources. All those are the issues why the judiciary is where it is. It's not because we don't have a good IT system. Of course we don't have a good IT system, but that's just secondary. So the question I'm going back to is, don't you think, considering your background, you cannot improve on the primary deficiencies of the justice system in this country as a Deputy Chief Justice?
I'm still confident that I can contribute to the primary business of the judiciary. And I think, as you have rightly mentioned, that you have listed out some of the challenges. One is incompetence. I think incompetence is an issue that can be resolved. Apart from the usual disciplinary action, first you try and see training. So training is a secondary business, but it resolves something that touches on the primary business. When you talk about corruption, again, culture change. Okay, would deal with the issue of corruption, because I believe that corruption is a culture, it's a habit. It's not about how much money you're paid. If you take a bribe today, I can't tell somebody tomorrow, I won't take it because I'm paid better today. That doesn't work. It's a habit, it's a culture. We've got to shake up the entire organization. That again, those energies come from secondary business. When you talk about independence, yes, that is something that has now been resolved by the law, hopefully. But also in terms of you can be independent and have access to the consolidated fund and be able to have financial independence or independence in the way that you conduct your work. But there are certain secondary issues that have to be dealt with in order to do that. And just on the issue where you say that the judiciary will, I'm very happy to hear that the judiciary will hire a director IT. if I went in as the position of Deputy Chief Justice, I would not be trying to do the job of a Director ICT. Even at Kenya Law Reports, we did have a head of ICT, brilliant person whose job was to focus on that. Currently, at my current position also, at the Electoral Commission, we have a Director of ICT, Director of Human Resources, but I think it is important that the training of the person who takes the leadership role has a broad balcony and umbrella view of all those areas. I am not an IT expert, but I understand how IT can be harnessed to be utilized to undertake my work, which is legal. My primary work is legal. I am a lawyer, but again, I realized when I joined in my career, I eventually moved to management. Yes, where I was working was highly, it was actually academic legal work, publications, and so on. But I needed to have managerial skill. When you think of the position within the judiciary, the Chief Justice and the Deputy Chief Justice have to have managerial skills. Hence the reason why I went back to study management, because I realized with my legal training alone, it was not sufficient. And if you look at, and again, using the example that the current position that I hold, I was appointed to the position of Deputy Chief Electoral Officer, not because I was an expert in elections, but I showed potential to be able to understand that. Election management is a highly legal work. It's defined by law. What you do under election management is defined by the law. So you needed somebody with an understanding of the law. But it's also a highly managerial position, operational project implementation, which I had strength in. With those two, I have a broader category, an array of professional qualifications that can help me do both the primary and the secondary. So I would plead that I have both.
Thank you. As I told you, we don't want to gamble with the candidates we pick. We want someone who doesn't have the potential. We want, a final product. So we are looking for a person, for instance, of great depth of legal and constitutional learning, ability to write judgments that enlighten, illuminate, and inspire. Where is the empirical evidence that you are such a person? Or do we take a leap of faith with you?
Thank you, Commissioner. I can confirm to you that you will not be taking a leap of faith with me. You will not be gambling with me. I am proven. I have a proven track record. When I went to Kenya Law Reports, I had never read judgments before, but I was able to do it. I had, when I took the current position at the Electoral Commission, again, I've served with distinction. I'd never done the job before. I think in most hires, people would be looking for people with potential. And I also believe the fact that the Judicial Service Commission took the brave move of advertising and opening the applications to outside the judiciary means that you felt that there is a possibility that the expertise or the abilities are outside there, not within the judiciary, because you could easily have decided to have an internal advert. I think my great depth, I have had the privilege of being teaching at the university. I have studied the law that's applied every day in the courts. It's my forte, so to speak, my bread and butter. Ability to write judgments, again, I expounded on the methodology for writing the judgment. Today you bring me a case, without having sat on the bench, I will be able to decide to it, because as long as I have the capability to grasp facts, the capability to analyze those facts and come up with issues, and then isolate those issues and apply the corresponding law to it, and make decisions and be able to set out the reasons for that. And remember, today in this age, again, the secondary functions, which allows me to access, I can today look at almost every decision on that point across the entire world. And therefore, I can confidently say that I will have the ability to write judgments. It is not something that you learn from writing a judgment. You don't have to have written judgments for 10 years to be able to write a good judgment. You just have to have an understanding of the law.
Thank you very much. I think you said that you are, because of your teaching experience, the University of Nairobi, you think you have the depth of legal and constitutional learning. I think there's a cliche in all academic learning where they say you publish or perish. You are there for 5 years, from 1997 to 2002, and I look at your resume, I don't see one article you published, whether locally or internationally. So how can we be certain that during those 5 years you taught at the University of Nairobi will satisfy us and show us that you have a deep legal and constitutional learning? Just to add a little bit on that, I mean, wasn't there anything during those 5 years that should have compelled you to write at least something that you ought to have published?
Thank you for that. I think in my work at the university, just the mere fact that I have not included some of the work that I did get involved, they were not necessarily published. Yes, there was work around the children and the law, matters related to children and the law, the subject that I taught at that time. There were documentation that was actually published, but as part of the cases that were submitted before the mock ICJ for students. So I was involved in academic writings, just not publishing in the traditional sense. And therefore, those I think I can say confidently that I was involved in academic writings. I have never had a break from academic writing, and then moved on to my job at Kenya Law Reports. I continued to do that, and so it's not in the traditional sense. I have 27 volumes of the Kenya Law Reports to my name. I have various materials which are, in fact, I probably have over 20 written academic work on various subjects within Kenya Law Reports that were not necessarily published because we were doing them as tools, but they can actually be fledged out as publications. And I know that I've been having discussions recently with some of the team members there that we probably should publish some of that work.
Thank you very much. Now let's go to, like some of the characteristics of a Deputy Chief Justice we are looking for is someone who has lived his life, if possible. I mean, some people may not have, but if they have, it's a positive, it's an advantage. Someone who has lived his life to show us that in light of the jurisdiction of the Supreme Court, in terms of the issues it will adjudicate, especially on Constitution, the Bill of Rights, that person understands, has internalized, has passion, and believes the principles of constitutionalism. Is there any evidence that you have done that?
Not in black and white, but as you can see, all the work that I have undertaken was to improve the administration of justice. And for me, that is my contribution, because you cannot have a forum on which constitutionalism is debated, analyzed by members of the bench without them being empowered. Like I said in my previous job, I focused on the secondary, as you may have put it, but it was actually intended to improve the primary, which is constitutionalism. I have done a lot of studies in the understanding of interpretation of the Constitution. I can say that over the years, in reading through various decisions, I can tell you that this person is an originalist in the interpretation of the Constitution, historical literal view. I can be able to tell you that this one is a modernist or has a liberal view. And I think that deep understanding, and I think the fact that I was able to acquire that knowledge from a situation where I was not under pressure, that I had the luxury of studying it and taking time and consulting and speaking, I can almost say that I was still learning and being taught every single day.
Okay, I mean, the two metaphors you used when you were explaining your understanding of the judiciary, both of them are troubling for me. One, you said, you have this balcony vision or understanding of the judiciary. Then the other one you said is that you have this umbrella understanding. I mean, I find both, I don't know whether it's subconsciously, to bring out that, you have a very small understanding. When you say balcony, I mean, there's a lot of things you don't see. When you see umbrella, I mean, there's a lot of things on top of your head you will not see. I mean, isn't it really to show that your understanding of the judiciary, whether it's a balcony vision or an umbrella vision, is limited, especially probably informed by your experience?
I think, Commissioner, based on your explanation of what your interpretation of balcony vision and umbrella view is, then I'd probably have to withdraw that description. But again, as I said, is that I do not believe any single person within a specific position has the mandate, has the power and the understanding of everything that happens. When I use these words, I use them in the context that I'm able to see more than the greater number. What I don't see, there will be members within the judiciary who see it. I don't believe that it would be a single-handed job. Where my strength lies is being able to put all these people together and focus to come up with a good result. Like I said, development of jurisprudence is not a section, it's not an individual, it's not a group of people. It's an entire sector-wide approach. which I think is something that can be able to be done, and therefore that even if my vision was limited, as you've said, even if it were limited, I don't think the vision of all the other people that I will work with will be limited.
Okay. Assume we recommend you for appointment to the... Let's assume if we recommend you for appointment to be the Deputy Chief Justice of this country, you will also be the Vice President of the Supreme Court. What will be your agenda as a Justice of the Supreme Court? What will be your approach? What will be your philosophy? What will be your passion?
First of all, my values and philosophy is that of excellence, that of efficiently, rule of law, justice, constant self-improvement. And I would bring that within the Supreme Court, because I would be, again, like I said, everybody is saying that we need a Supreme Court so that it can settle the law, so that it can explain the law, so that we can have a rich base of case law, which has been felt has been lacking. Again, I said that I do believe that some of the reasons why we haven't had that is because the entire system was not a conducive environment to produce that, or there was competence issues, as you said, which I agree with, and we can build on that. My focus, if I were to be appointed that position of Vice President of the Supreme Court, I would immediately take to, and like I said, I believe in data. I would analyze it and ask, and together with all the other members who would then have been appointed, and say, what is it that is expected of the Supreme Court? And what is it that has been felt has been the shortcoming of the Supreme Court? And all that has been documented. So much, again, has been written in this country about it. And based on that, we would develop a master plan to undertake it. I do not think that setting up committees is going to help it. It's going to be about focusing and saying that this is what we know is the problem. This is the result that we want to get. And that's why I said is that I would... And the rapid results initiatives that I have mentioned a few times now is within each context of each court, you would be able to design that from looking at it, analyze and say what went wrong, what were the causes, what can we do to improve it, which ones can we achieve immediately, which ones can take long term. And like I said, development of improving even clearly, and making sure that there is a clear understanding of all the members of the Supreme Court of what it undertakes. I think when I've listened to all members of the bench across the entire bench strata in the judiciary, the one that resonated with all of them was the issue that you would be appointed to a position and then suddenly expected the next day to start delivering results. Yes, we don't have the luxury of taking too much time about it. But if there's a clear understanding on that, a quick discussion on that, and be able to come up with what the Supreme Court should do, I think we'd be able to come up with a master plan of what we need to do.
I will ask you two questions, hypothetical, because I want to understand your philosophy of law as a Justice of the Supreme Court, as the Vice President of the Supreme Court. And the first one is, if you look at the history of Kenya, the political space we have, the constitutional reforms we have come out principally because of the agitation of people. I think many years back, there were even ladies who undressed in Uhuru here. In your view, and the Bill of Rights, is very expansive, unlike the old constitution, it has, various generation rights. In your view, is there a right to break the law?
No. I do not believe that there is a right to break the law. I'm a strong believer in the rule of law. I'm also a strong believer that people cannot completely be servants of in most of the times where they've had challenged the law. It's not really with the law itself, but the technicalities that come with application of the law. And that's why I'm happy to know that the current constitution actually says that we shall focus on the substance and not the technicalities. I think the agitation by people is something that will have to continue happening within this country. That is not the job of the judiciary. That is the job of people out there. I believe that every case, if there is enough cultural change within the entire legal sector so that lawyers can bring certain cases. The current constitution provides a great forum for public interest litigation. Those are the ones that will redefine the law. Those are the ones that will define develop the jurisprudence of this country. And as those judgments are written, again, the role by scholars will be played. And that's why today you can, in the US Supreme Court, people are able to clearly say that there is the two wings, the liberal and the conservative, but that comes from studies by scholars on an analysis of various decisions from that particular court. I think, I believe, my philosophy also, I'm a strong believer in the vibrancy of the common law system, where interpretation is different for every judge. And therefore, I think it's a great situation when you have judges of varied positions and beliefs and philosophies, because the sum total of those philosophies comes out with one that is conducive for the entire country. I think it would not be proper to have only one extreme view. I would like to see a court of appeal that is diverse enough to have those who have got a liberal interpretation, those who are strict interpretation of the law, because they also bring something to the table. But based on that and all those, application of their various schools of thought is what will make the Supreme Court, so it's also the people that will be at the Supreme Court, rich jurisprudence will come out of it and therefore can develop.
Of course you are entitled to a view, but I mean, don't you think if you look at the history, and you give us some cases about America, I mean, if you look at, the civil rights movement in America and, many societies that have made strides, transformative strides, most of those came out from breaking the law. And the subsequent litigation, changed the law. I'm not saying you should not believe in this, but when you say you don't believe a right to break the law, I mean, doesn't that paint a picture of a very conformist status quo person?
I am a person who has a philosophy of belief in the rule of law, but with a liberal view. For example, when you think of, even if we just take the example of the Brown versus the school board, which dealt with the separate but equal concept in America, when you did look at that, there was a lot of civil action that actually culminated in that case being brought. This kind of philosophy and jurisprudence, everybody plays their role. There will be those people who, and I believe everyone has a contribution in society. There will be those who will contribute through civil action. There will be those who will contribute by being able to help that civil action come before the court of law, like lawyers like yourself providing pro bono services for that kind of public interest litigation. And then there will be those who will play their role interpreting the law and liberally and in a very modernist way, and therefore be able to relook and say that issue of separate but equal is. So I believe that everybody has a contribution. I don't think one single person has the ownership of that process.
Yes. Okay. The second example I would like to see is, on May Day, I think Francis Atwoli, that Secretary General of Kotu, said they will strike soon on the issue of minimum wage. In your view, again, it may be, is the issue of a minimum wage a political issue or a constitutional issue?
I think if I was sitting on the Supreme Court, it is something that I would wait for it to hit the courts, because we have no power as members of the bench at that stage.
Your view, what's your view? Not us. What's your view as Shollei?
The issue of minimum wage, it's set out in the rights and labor relations within the Constitution, so it is a constitutional issue. But depending on the facts of that particular case at the time when it is presented, then the law will be applied appropriately. But yes, minimum wage is things that have been talked about and has been developed over years with people like the trade unions taking action, going to court until the matter is finally have to be resolved. So I would encourage, I believe that, and I think some of the greatest developments we have made in this country relating to these subjects has been also through agitation, court action, and reliance on this by the courts.
Thank you very much. Now, the issue of stare decisis, I mean, I think during our interviews we have been asking every candidate that issue. Some of us have taken a narrow view of what stare decisis is in the common law jurisdiction. And I would like to ask you, I mean, you also gave us, the American cases of Miranda. And both the Supreme Court of America at various times thought that Miranda was wrongly decided. They also thought in actually not very recently, but I think about 5 years ago, the Chief Justice of America, as he then was requested, had enough numbers to overturn Roe v. Wade. And he actually assigned himself to write the majority decision overturning Roe v. Wade, thinking that, there's a consensus suitor who normally votes with him, or who, I mean, is fairly both sides, but he's normally thought to be a conservative side judge, said that he will not overturn it because it is a precedent, whether it was wrongly decided or rightly decided. And I think stare decisis, in my view, does not just mean that you follow cases if they are similar. A very important component of stare decisis, and it's captured in a dictum by one American Supreme Court when he says, it's better for the law to be settled than to be settled rightly. So in America, even though they think, for example, that Roe v. Wade or Miranda was wrongly decided, there is a large component of the American Supreme Court who will not overturn cases that were even wrongly decided because it establishes a strong precedent. Let me read for you a paragraph from this book. When Justice Antonin Scalia was asked about what is the difference between him and Justice Thomas, both of them are on the right side. But this is what it says. Probably the greatest contrast between Thomas and his colleagues was that he fundamentally did not believe in stare decisis, the law of precedent. If a decision was wrong, Thomas thought that it will be overturned, however long the case may have been on the books. As he wrote once, and I quote, "When faced with a clash of constitutional principle and a line of unreasoned cases wholly divorced from the text, history and structure of our founding document, we should not hesitate to resolve the tension in favor of the constitutional original meaning," end of quote. All justices of the Supreme Court, from Brennan on the left to Scalia on the right, developed something close to a reverence for the court's precedent. No one besides Thomas will have dismissed 200 years of stare decisis in such a cavalier way. At an appearance in a New York synagogue in 2005, Scalia was asked to compare his own judicial philosophy with that of Thomas. I quote, I am an originalist, Scalia said, but I am not a nut. End of quote. So a major component in America on stare decisis is that even if a case is wrongly decided, as long as it is 50 years old or 70 years old, it's better for the law to be settled than to be settled rightly. Do you think in Kenya, I mean, especially from your position as an editor of the Kenyan Law Reports, do you think that component is part of our laws or appreciation of what stare decisis is? And secondly, if you are a justice of the Supreme Court, will you leave certain cases unturned or leave them on the law books even if they were wrongly decided, but they have established a strong precedent?
Okay, thank you. That is very interesting academic discourse, and I'm very impressed by it. I think if I gave the impression that I think that the doctrine of stare decisis is sacred, that is not my position. It is not sacred. Like I said, I'm a modernist. I interpret the Constitution at the law, at the time, as if it was ratified today. I believe that the law is alive and must respond to development in society. So, of course, the originalists just believe that they will always go back to what the framers of the Constitution thought and believed at the time, and will stick to history. I do not believe that we must sit back and stick to history. I have a different view, but I do hope that if I ever have the honor of sitting at the Supreme Court, that I will sit together with other members who have the literal view, because then those are people who stick to a literal interpretation of the Constitution. But hopefully, based on that, will be able to move the Constitution forward. I do not believe that the doctrine of stare decisis should be applied for the sake of it. Yes, during my tenure as editor of the Kenya Law Report, in reading judgments, sometimes I could see a judgment where it's clearly the judicial officer, basically because of lack of time or not wanting to put not wanting to put too much time into the case, would fall back. It's a lazy option to stick to the doctrine of precedent. It's very easy. If you don't want to stress yourself, that's an easy option. You say, this precedent says that. I think where the difficulty comes and the bigger challenge is when you have to distinguish and move away from precedent. And that is why that with the correct resources and the correct support, you will have more judicial officers distinguishing precedents. Because in most cases, I saw many cases where they stuck to precedent, but it was obvious that they had opportunity to distinguish that precedent. I also saw opportunities where the Court of Appeal had the opportunity to overrule their own previous precedent, and they didn't seize the opportunity. In other cases, they did. And so, in terms of, I believe that the law has to, and that's why I said the vibrancy of the common law system, where you depend on the interpretation of the judicial officer, the interpretation depending on whatever school of thought they belong to, the interpretation depending on how they view the response of the law at the time and the history of the country. And therefore, I do not believe that you stick to precedent for the sake of precedent. I believe that you should be able, and I would like to put in systems and assist in development of systems that make it easier for judicial officers to take the brave decision of distinguishing and overruling some of the. In some cases, they reclarify the law, they expand the law again, but that, again, also is completely the blanket involvement of the entire doctrine. So I do agree with you that I think it is not proper, and many people may not agree with me, that we stick to precedent for the sake of it.
Okay, I mean, that worries me a little bit, because I'm not saying you are, I think that really worries me, because when a judge of, that sits in the Supreme Court says that stare decisis doesn't matter much, I mean, we have enough already in our justice system. People who have given themselves a elastic space, say that this precedent can distinguish on very narrow grounds, so that, they can go to determine issues on a preconceived, or a predetermined manner. And the good thing about the stare decisis, like in America, is that, I mean, it narrows down the discretion of a judge to deviate from a matter. And distinguishing, like you find in Kenya, doesn't mean, a personal appreciation of the issues. And I think why the American jurisprudence has developed the way they have is, is a respect for the reverence they show to formally decided cases. But don't you think that when you say stare decisis does not really apply, or the Constitution is a living document, I mean, don't you give your judgments a personal flavor of what you like, what you don't like, how you interpret the environment, how you see, understand the dynamics of the politics at that time? I mean, doesn't it create a very chaotic system of not being able to predict what the law in this country is with any certainty? Because the judge will say, as you said, I mean, I support, that the law is a living, or the Constitution is a living document, and I will decide the case as of that time. I mean, isn't that a very nihilistic interpretation of the law?
Again, I am not saying that the doctrine of stare decisis does not matter. What I said is that people should strive to, where necessary, when the facts and the law call for it, to distinguish and move, because you can move away from precedent and stare decisis, the doctrine applied by actually distinguishing and saying this case is not the same. The difference here is ABC, and that is how it's done. So what I'm saying is that you can move away from that doctrine only if it is justifiable within the law. And I think you said something else that I think I'm trying to remember. But when you think of it, the law can never have. You can never say you're applying the law with a personal flair, because ultimately you will have to apply the law and you will have to explain why you applied that law. You would have to look at other precedents and say where this particular case before you is different from the others. That, in fact, I don't think in a common law system there is actually too much room for discretion or personal flair. If you undertake that, it will reveal itself in the way the judgment is written. And I have had the occasion to see judgments that reveal that. And again, I said this is a hypothetical discussion we are having, because I think if I were to clearly come up with a view on a specific matter, I would need to have all the facts and all the laws on that particular case. Right at the moment, we are speaking on generalities on it, and I think you'd understand on that fact. But if I had a specific case, I wish and I do hope, I wish that this interview had a situation where you give us a case and we actually make a presentation on what our views and discourse relating to that case is, including some of the writings that have been made. It would have been easier for you to reveal what my theory or understanding is. But under these circumstances, it's not, I don't think I can sufficiently give an explanation. I hope you do understand this limitation.
I understand. My last question is that, as an editor of the Kenya Law Reports, you said you have analyzed many judgments. I mean, you have a deep understanding of, the thinking of the judges who wrote those judgments. When you look at the worst judgments or judgments that have overturned established precedents, whether the High Court or the Court of Appeal, the following three reasons or factors which will make a judge, overturn, an established principle. One, in my view, is sometimes is sheer incompetence. The second one is sometimes there is political influence to deviate from an established line of legal precedent. And thirdly is corruption. We have seen cases where the courts, High Court and the Court of Appeal, have deviated from established precedents, especially in commercial cases and contract cases. In your view, having analyzed or having edited those many volumes, is it fair to say that those three factors play an important role in creating instances or explaining instances why the court, whether the High Court or the Court of Appeal, deviates from precedent?
Yes, you're very right that those are actually some of the factors that contribute to that deviation from precedent. But, and I did come across many of them during my time. But I do remember many times I was frustrated and hoped that there was an opportunity or forum for us as the editorial team at the Kenya Law Reports to be able to present this to a higher authority, to be able so that the action can be taken on them. I know that had the forum existed and had our mandate allowed us to be able to make those, because we could see clearly. It was very clear when you read a judgment that this is a clear case of lack understanding of the law. Sometimes you'd say this is a clear case of really bad bias. Sometimes you'd see a clear case of corruption. In some case, you'd be a clear case of just not being in a hurry, in a rush when they write the judgments. We did see that. But our mandate did not go beyond that. We were not able to have a forum to submit that. I do hope that one day that the judicial system or the National Council for Administration of Justice shall be able to harness this database that the Kenya Law Reports has, this information that they come across, and be able to use it in order to resolve, because it would have been easy to pick, and it's a pattern. You can almost study it, and it's based on personalities, and I did see that.
Thank you very much, Chairman. I must commend the candidate for the manner she has answered questions, and I thank you also.
Thank you.
Attorney General would like to do some follow-up questions.
Just want to give you an opportunity to explain something. Under both the Constitution and the Judicial Service Commission Act, you are both head of Judiciary and head of Supreme Court. The core function of the Supreme Court is to hear and determine appeals, to interpret the Constitution. In other words, it's a judicial function at the very highest level. Therefore, your answers to this, you said in answer to a number of, that's hypothetical. You have been to America, and when they are interviewing candidates for the post of Chief Justice, or in fact any judge, they want to determine the school of thought of that judge. Is he a liberal? Is he a conservative? Is he a positivist? Etc., etc. And in doing that, they look very, very closely at the decided cases that judge has written. They also look very closely at the written articles that judge has written. Now, for us, as you have admitted, there are no such judgments. There are no such articles that you have written. And that's why the discussion has become hypothetical. Because maybe had we had those judgments, we would more or less be questioning you on that one, so that we know your orientation and your school of thought. Therefore, it leads me to ask this question. Because we obviously have very strong marks in the area of management and IT. There you are a high flyer, if I may use that particular word.
Thank you.
I would like you to explain why you think that you more qualify to be for the position of Deputy Chief Justice rather than other posts within the judiciary. And let me just read you. There's another post within the judiciary, both under the Constitution and under the Judicial Service Act. For example, the post of Chief Registrar. Under the Constitution, the Chief Registrar is the Chief Administrator. Okay? Now, under the Judicial Service Act, the Chief Registrar also has some judicial functions, but it says perform judicial functions vested in the office of the Chief Registrar by law. And those judicial functions involve decision making, making rulings and so on. Yeah. Which of course you are competent to do, because you have a master, you have everything that goes with it. But the main one is overall administration and management of the judiciary is in the Chief Registrar. The other one I'm not reading all, just something maybe. Be responsible for the efficient management of the day-to-day operations and administration of human resources in the judicial service. Be in charge of the support services, in particular planning and development. Monitor and enhance administration and office procedures to maximize on efficiency and quality of service, amongst others. Now, when I read your CV, it does appear to me that you have very, very strong points, as you have admitted, on the support systems, on the secondary systems, which create an enabling environment for quality judgments to come out at the end of the day. And therefore, my question becomes this. Why do you think that you qualify more to be Deputy Chief Justice? Because how do you know how to explain yourself? You could have more to be Deputy Chief Justice other than another constitutional office called Chief Administrator of the Judiciary, in the light of your qualifications and experience.
Thank you, Commissioner, Mr. Attorney General. I see you're offering me the position of Chief Registrar, but I've currently applied for the position. That's with a light note. I think currently I have applied for the position of Deputy Chief Justice, and it is what we have been discussing. I have gone to great lengths and taken great time, and I know that I've taken too much time of your time, actually, and to try and explain why I am best suited for the position of Deputy Chief Justice. When you talk about, you clearly show that it's your frustration is that you're not able to quite tell what my school of thought is, what is my philosophy, how would my judgments be like, isn't it? I can see that, and it's coming out clearly, and I think from Commissioner Ahmed Nasir, that seems to be his worry. But, and I think when you say that in other countries where they have this kind of hearings, they use that format to study. Yes, they will use your writings if some are available. And if your writings are not available, what the interview panel would actually do, or the panel before which you appear, will serve you with certain judicial decisions in advance and ask you to make a presentation and discussion relating to those. From that, they can denote your thinking. I would have loved the opportunity, and in fact, I think it's almost necessary that I should have had the opportunity to do that, because I think I would have been at my best element. And I would have left you with absolutely no doubt in your mind that I'm the best person for the position of Deputy Chief Justice. I do hope, I wish I had had the opportunity to do that. Had I thought that this would have been an issue, I would have actually, because I've done writings on that, I have studied various jurisprudence, except that having not done it for the last 1.5 years, I would, and usually, because again, remember, if I was writing a judgment in the Supreme Court, I would have sat down, I would have had time to dwell on that case, to scrutinize the facts and the law. So it is not something that you casually spend a few minutes to say it, because that would mean you've not applied your best mind and the law to that particular case. I would have liked the opportunity to do that, and therefore I would be able to. I think in what I have already done, I think when you talk about those duties that you have set out in the position of Chief Registrar that you've set out, yes, that sounds like a lot what I've done. It's, that's my forte, so to speak. But that's what I've done before. It's what I'm doing now at the Electoral Commission. I feel like I need to move to the next level, hence the reason why I've applied this. I also believe that that experience that I have got within the job description that you have described at the moment is what will enable me move to the next level. I have done that job before, and I think that is what makes me better suited to be position of Deputy Chief Justice. I don't know if I've answered you well. Yeah. Thank you. Thank you, Mr. Attorney General.
Thank you. Thank you.
Thank you, Chair. Mrs. Shollei, yes. Mine is to ask on leadership qualities, initiative, resourcefulness, drive, and having listened to you, you have really covered a lot of that on what you have done in the National Council of Law Reporting. But Commissioner Mwangagi asked you something which you did not respond to very well, and I want to repeat it. Yes. As the Attorney General has read to you, offices are very well defined in the Constitution and also in the Judicial Service Act. Now, the office of the Deputy Chief Justice, it is simply stated that the functions of the Deputy Chief Justice will be to deputize the Chief Justice. We are not told in what or how or when. You notice also that in the Judicial Service Act, the office of the Chief Registrar is really well defined on the functions and what the Chief Registrar shall do. Now, the Chief Justice being the head of the institution, and then the Registrar being the Chief Administrator, what, in your view, would the Deputy Chief Justice then do? Like you said that we'll say it, maybe it will be a team thing to decide that this is what the deputy will need to do so that roles don't overlap. But in your view, what do you see as the functions of the Deputy Chief Justice?
Thank you for that, Commissioner Ominde. from looking at, and like I said, because it's not clear what the job description is at the moment, and you have rightly put it that at the moment this is all we have, but there will come a time when it will be defined. But for what I can only fall back on, and before I applied for this job, I looked at the positions of Deputy Chief Justice in other countries. In most countries, depending on the issues at hand and the issues that were the biggest agenda within the judiciary at the time of appointment, then the position of Deputy Chief Justice would be designed around that. For example, I said that I've seen in some countries, apart from sitting in the Supreme Court, the Deputy Chief Justice deals with judicial operations and reform. I know that this particular docket will definitely have those two issues, judicial operations and reform, because it is the most critical issues, improving efficiency of judicial operations, overhauling judicial operations, undertaking judicial reform. I believe that those two issues will never miss in the current position of Deputy Chief Justice, and that's where my strength lies also, apart from understanding of the law. I also believe that, I've also seen that in other countries, when they are at a time that they need to reanalyze their work, then you find that the Office of the Deputy Chief Justice also deals with collection and assessment of statistical data that informs the judiciary in the way to move forward. This is critical information that the National Council on Administration of Justice will require. And again, I said that is where my strength lies. I will also be, I see that the National Council on Administration of Justice should be chaired by the Chief Justice. And as you deputize the Chief Justice, that really, you would have to consider yourself that you should be capable of undertaking all those roles set out for the Chief Justice. When I look at the National Council on Administration of Justice, it's actually designed in the Governance, Justice, Law and Order Sector Program system that was running under the Ministry of Justice. Like I said, I had the honor of and privilege of serving as a co-convener for the Justice Group with the Registrar of the High Court. And it looks at a sector-wide approach. I know that even to my name, during one of the reports and findings of the Justice, Law and Order sector, they notably said that the reform sector had succeeded. The sector-wide approach had succeeded in some areas, and they isolated the case of national law reporting under my leadership. I do also think that I can contribute in that area, because obviously I will be assisting and deputizing the Chief Justice as chairperson, which means setting direction and looking at the correct agenda for the National Council for Administration of Justice.
Thank you. Thank you. Now, you said that perhaps the most critical area would be judicial operations and reforms. Now, in the National Council on Law Reporting, you have been based in Nairobi, basically. Problems in the judiciary or challenges that face the judiciary have been identified. They cut across the board: their infrastructure, their human resource, their case management, court management, funding. Now, I'm looking at a scenario where you're Deputy Chief Justice and you're told, tell us what kind of operations and reforms we need to put in place. Given the fact that you have never sat in a courtroom, you have never encountered this very heavy cost list that everybody is talking about, you have never had to have this heavy cost list, have this manual recording of proceedings, have to sit in, late into the night to write judgments. I mean, you have never really been out there to be able to empathize with the kind of conditions, working conditions that judicial officers go through every day to deliver even a judgment, good or bad. How then are you able, assuming that in reforms, you ask, what do you think we need to do about the human resource in the judiciary to be able to improve? How can you empathize with them sufficiently to enable you correctly diagnose the problem and propose a solution that would immediately work?
Thank you for that question, and that's a good question because it gives me an opportunity to cover an area that I did not manage to cover. I think, on the contrary, I do apologize for giving the impression that I did not operate outside Nairobi. If I just look at within my experience within the Kenya Law Reports, when I was appointed there at the beginning, I thought I would find judgments at my desk. I did not find judgments at my desk. The Attorney General, when he appointed me, did not say that to me. And I had to, but these judgments, so I went to the High Court within Nairobi and asked the registrar, where are these judgments? And they said, oh, they are in archives distributed all over the country. I then had to design, at that time we didn't even have staff members because I was just at the fact-finding stage. I did not understand how we will be able to get all these judgments. So what I did is I actually went to all the main court stations, and most of the files, the court files, were actually stored in under the deputy registrar within that particular court, who was like the manager of that court. And I had the occasion to go. I have never seen archives like that. I have never seen papers on top of paper like that. And as I did that, because it was the magistrates in charge of that station that took me around, I was able to discuss with them and understand their challenges. I remember I toyed with the idea that they would help us in collection of judgments. And I tried to convince many of them. And I can say of all of them throughout, I think, the 14 high court stations where there was each a deputy registrar, all of them said without doubt, we are so overwhelmed, we cannot help you. We can facilitate it, but we cannot really, because at that time I dreamed an idea of that the people in charge of collection of these judgments and transmitting them to Nairobi would be done by the deputy registrar. It was at that time that I realized the deputy registrar was actually everything. They were managing the resources, they were hearing cases, they were in charge of the entire station. I have never seen more overwhelmed jack of all trade people before. I commend them and have great respect for the magistrates, and that's why for many times I said 90% of justice delivered at the magistrates. And therefore I empathize and understand. I spoke to many people, yourself included, on the challenges. I met many magistrates who explained what the challenges were, and so therefore this going through the courts. And remember, throughout and after that, Kenya Law Reports established a system where we had what we called collection agents scattered all over the country. Their job at the beginning was to go to every registry under the direction and supervision of the magistrate in charge, pick out every file, remove the judgment, photocopy it, put it back. I know the challenges that sometimes we couldn't get paper. I also know that there were times that we had to use commercial photocopying equipment outside the court building, and there was some very resourceful magistrate who said maybe the vendor can bring the equipment within and so the photocopying can be done by our officers from that particular stage and then charge per page. I know that they didn't even have access to courier services. I think by the time I left the judiciary, it's one of the things that the current registrar can get credit to. We actually had an official courier system that delivers things from all high court stations. But in the past, at that time, we used to put them on a Kamba bus, on matatus, anything. I mean, so and that's why I said I used to be a big critic of the judiciary. When I joined, I could not imagine more overworked, service-oriented people. Those are the people who make sacrifices for this country. Yeah, they will not, and they do not have the flexibility. A magistrate cannot buy paper. They have to toy between buying paper or between being able to clean the office, they get someone to clean the toilet so that they can not have to live with the stench as they produce their cases. I have seen the challenges of all, and I can say that without fear of contradiction. Luckily, also for me, the current position that I have served at the Interim Independent Electoral Commission, I even got a further baptism by fire induction of what happens in the country. I had never known that there were places that you drive for 200 kilometers before you see anybody. I didn't know there were places that you can't even go by car during certain times of the year. I can say that I now understand my country perfectly. And for me, the opportunity that I have served, I'm glad that I am applying to serve at the judiciary after I have served at the Interim Independent Electoral Commission. I have seen in my time at the Electoral Commission that I would prepare a budget and say that bread is 35 shillings, only to discover that on the ground is 100 shillings. Because people have to drive all the way to get it. Places that you could not be able to find milk, because that's a granted that, you know, you can buy milk for the officers, they can have milk and bread. It turns out they may have the money and not have access to it. To get it, they will pay 4 or 5 times. And that's why when I look at some of the challenges within the judiciary, access to justice for the public, it is unfair to tell a member of the public that you pay 6,000 shillings filing fees and it's the same price for the entire country. Those are some of the lessons I've learned at the Interim Independent Electoral Commission, knowing that surely it can't be 6,000. They're not looking at the socio-economic challenges of each particular region. 6,000 shillings to come by at the tip of Turkana, Marsabit, and Mandera is not as easy as it's easy to come by in Kiambu. And so those are, I think I'm better prepared than any other time in my life for this kind of challenge. If you look at the program which I initiated, and I did personally approach USAID to assist in the development of a case tracking system that is currently going on in the Magistrates Court in Eldoret, and also that was undertaken, and I think we worked together on that, Commissioner Minde, at the Family Division. There were simple solutions that I know that when we worked together, when we undertook the case track, we discovered so many files that had fallen through the cracks in the system and cannot be found. Again, it made me understand the challenges that face all the judicial officers. Yes, I can be brilliant and want to work on my cases, but if I can't find the file, what am I to do? And so I had the opportunity to see that. I watched, I'm particularly very proud of the system that was recently launched at the Eldoret Law Courts, because when we started, there was no resources. Kenya Law Reports was supposed to undertake it. We didn't have enough staff members to send there, and therefore the capacity had to be built on the ground. I must commend the then Chief Magistrate there, and also the one who succeeded him. And they took it upon themselves, and I remember they learned themselves first how to undertake the case tracking. If you look at the Family Division, the same thing happened. The officers there had to learn. It's not easy to learn a new job and to learn to do something differently from the way you worked, especially when doing this was a pilot program and was not going to the actual performance of my work. It was double work on top of already over-exhausted, overworked system. I also had the privilege of undertaking the digital audio recording pilot system at the Chief Magistrates Court here in Nairobi, and that again was funded by the World Bank. I was instrumental in finding the resources to undertake it as a pilot. And I thought it was a simple business, and I said, we put the equipment there, you run the system, and we can audio record and people can type it. What I hadn't understood is that the ambience and within the court was so bad, such that it was not good for audio recording, and you'd have to get special equipment. I didn't understand about noise filtering. I didn't understand that parties and litigants coming before the court together with lawyers spoke about several other things long before they started the actual case. So the Chief Magistrate said, but it can't work like that. You'll be recording 50% of things that don't need to be recorded. Again, it was a learning experience. And for me, I value that interaction because I got amazing knowledge. And as I said, sometimes learning is just from speaking to people and interacting with people. And I think I have a teachable spirit. I can empathize with people when I listen, and I'm constantly seeking solutions for anything. The word impossible doesn't exist in my vocabulary. So every time I see a challenge, I think, how do we fix it? And what I learned most importantly, that each of those magistrates in all the regions without exception throughout the country actually knew the solution. Because I would ask, suppose we give you a blank check and tell you fix this court. They all had answers, amazing ones that no one, even in all these reports that were done in Nairobi, by very senior judges could not have come up with. And so I also would like to encourage and make it possible for these judicial officers to be able to design their own programs. They should be able to know how to make arrangements within, of course, some framework. But they have the answers. It doesn't take one person to do it. My strength would be to be the enabler of that to happen. It would not that I will do it myself. I'll be an enabler. I hope I answered the questions.
Yes, thank you. In fact, you've answered most of the questions that would have come after that one. So I am generally also designated to inform you of what the public thinks of your candidature. I wish to state that they said they don't know you, and so they have nothing to report. So my last
good sign.
Maybe if they knew you and have nothing to report, it would be better. Now, my last question is this one. You are young, in your early 40s. You have been a lecturer. You were at the National Council on Law Reporting. You really pioneered it. It was doing great. Soon thereafter, you left the Electoral Commission. We have not yet had elections. You want to come to the Supreme Court? I mean, how are we going to pin you down? How do we make sure that Gladys has come to the Supreme Court and she will be here with us for the next 10 or 15 years until we settle the law? Do you have staying power, Mrs. Shollei?
I think I would answer that. I have staying power now because I'm older. And I think I must correct you. I don't consider myself young. I know people have said that I'm probably too young for the job. But if nothing else, this was a clear indication. The current chairman of the Electoral Commission is younger than me, but he was able to do a sterling job and show the country that age does not matter. You can deliver no matter your age. He restored election confidence in voter confidence in election management. Yes, but yes. So for me, but I think it's important to point that because I did say to our chairman that you vindicated the young people of this country in the way that you manage the Electoral Commission so far. And I strongly believe in that. And I think at one point I was holding my breath that if he performs, then people will begin to believe in all of us. Staying power, I think the way I would put it is that I always believe that, I've always been a strong believer that wherever I work, I must make an impact. That's my philosophy in life. At the time when I went to the Kenya Law Reports, there was nothing. It was a completely fresh institution. But the only thing that drove me there was that I can make an impact and I can make a difference. I went in there and I was able to make an impact. I built it to a position that it is known all over the world. But the question after that I asked myself is that, is there anything more for me to do at the Kenya Law Reports? There was nothing more for me to do. I had done everything that needed to be done within my power unless my mandate was expanded, which couldn't be because it's set out in statute. And for that reason, I said to myself, because I am not one to, if there is nothing more to do, I am not one to sit in the same position. If I'm not making a difference, making an impact, and feel that I'm fully being able to contribute that all that I have and give it all my intellectual abilities, then I would not stay in a place. I think it would be wrong. I don't believe in mark timing in a position. But when I moved so I've been at the Kenya Law Reports. When the opportunity to apply as Deputy Chief Electoral Officer of the Electoral Commission, remember the history at that time. Kenya had almost gone to the dogs. I thought about it and I said, you know, it's a blank check. It's a new floor. I mean, it's amazing playing ground. You can do everything there. It's a great opportunity. And of course, being a mother, I tell myself, I don't want to end up in a refugee camp with my children. I want to make sure that this country is safe and stable. If I can contribute, even in the smallest way, to make sure that happens, I will offer myself. And that's exactly what I did when I took the position of Deputy Chief Electoral Officer at the Electoral Commission. But remember, I had spent several years of my life understanding the judiciary and seeing all these challenges and did everything that I could to do whatever little process of reform that I could contribute within the judiciary. At that time, there was, like I said, there was nothing more to do. But in doing our work very well with the great team at IIEC, for whom I have the greatest respect, we were able to help Kenya midwife a new constitution. That new constitution provided immense opportunities for reform within the judiciary. Immediately my head started ticking and I said, my God, I wish I was in the judiciary at this time. You know? And remember, my heart was always at the judiciary. I'd like to live to see the day that that judicial officer who has no paper, who has to sit next to a toilet that doesn't work, that has no power, has to manage resources, do everything, is not trained, is overworked, underpaid, that I can improve that I can participate in that process. I also, look at, we dreamed of the day that social, economic, and cultural rights would be in our constitution. Now it has happened, it's for real. I remember public interest litigation. It was not possible. Now it's possible. It's in the Constitution. What better place than to be in the judiciary at this time in our history? Yes, I toyed with it, and it was difficult for me understanding that we have an election next year in 2012. But I don't believe that the stability of the current IIEC depends on me alone. I know, and I have, that there are great officials there. I was not the only person. Yes, I was leading a team, part of the team there, but I have complete faith in all the members of the Electoral Commission that they can work. It is an institution. It's not about one person. And so I did and had a discussion with my chairman, and with a very honest discussion about it, and reluctantly said, I think give it a shot. He understood. He understood that my passion was always with the judiciary, and he said, if you can get in, so be it. But and so yes, I had to weigh between the unfinished business at the judiciary and the unfinished business at the Electoral Commission. But again, in every place there are Kenyans, very highly motivated, hardworking, competent, honest to God, hardworking Kenyans that can still do the job at the Electoral Commission. And I have no fear. If I thought in my mind that I still needed to be at the Electoral Commission and that certain work couldn't happen unless or I had work that I had not completed and need to follow through, I am not one to shy from that. I would actually go back. Yeah. Thank you.
Thank you, Mrs. Shollei. Thank you, Chair. That will be all from me.
Professor.
Thank you, Chair. Thank you, Ms. Shollei. You have really impressed me as being action-oriented, and it would have been my pleasure to see you midwife the Constitution until we have the first election through, so that we know what you have put in place is workable. But having said that, that is no reason not to welcome you here, if you so desire. Now, in this country, since I represent the public out there, there are challenges as regards to human rights, especially to the marginalized, the vulnerable children, the women, the physically challenged, and all the marginalized groups in this country. If you became the Deputy Chief Justice, how would you actualize the Constitution or their human rights in your capacity as a Chief Justice? What deliberate actions would you put in place to actualize the implementation of the human rights for these marginalized people?
Thank you, Madam Professor. Yes, there is so much you can do as a position of Deputy Chief Justice on this, and even just as a judiciary as a whole. Again, I'd like to say that this would take a holistic approach that all members in the judicial sector would be able to appreciate it. One of the things that I would first have to do is ensure, because the human rights concept and the Bill of Rights that is current in our new constitution is new, we would need to re-educate and retrain all the judicial officers to have an understanding of this. We will need them to understand what it is to be what a marginalized community, the kind of challenges that they face, so that when these people come before the courts, they are able to understand. They will also have to understand various conventions and writings and and law relating to women, gender issues, and the vulnerable. So for me, training would be important because this is a new constitutional dispensation. You are dealing with a group of officers who have always studied and understand the old constitution like the back of their hand. They would need to leapfrog to the new one and have a complete. So for me, training, root training would be very important. I would also, and you find that when people have a higher understanding of a subject like human rights, their decisions tend to be able to appreciate that aspect of the law better than they would ordinarily have appreciated had they not had understanding. I would also deal with, because when I talk about human rights and poor marginalized, I was thinking as from within the judiciary, this, access to justice must be available to all, including the poor marginalized, those who are vulnerable, and so on. We want to be able to, and I did see in in my travels that sometimes you find that a court is so far, so as can be said, it is not accessible. Or sometimes you find that the judicial officer who's there, even in a court that exists, is so overworked that the person's case may not be heard soon. That again makes it inaccessible. Also, even the issues of cost, the cost of going to litigation, I think also is an issue. The availability of legal aid, I would revamp and improve legal aid and pro bono, the whole culture, inculcate a culture of public service. I do know that during my time at the university, we established a legal aid clinic for students, where students would help do research in pro bono on certain cases, because sometimes a senior lawyer is willing to take pro bono work and undertake legal aid, but they may not want to put in the hours it takes to undertake the research. You can get the students to help you do that, and the students can do it as part of their studies. And there actually was a subject which was introduced during my time. It was called Public Interest Clinic. I had I taught it, the practical aspect of it, and I had the opportunity also to understudy a senior professor, and went to a country where students actually appeared in court for the poor, but with their professor who's an advocate, supervising them just to make sure they're on the right track. But they are giving a public service, but at the same time they're learning. So you kill two birds with one stone. I would encourage programs like that. And I think, just in a nutshell, that there's much more you can do, but that I think I can say would be the first ones that I'll deal with.
Thank you. What about the aspect of getting the public also to understand the law? You know, what we don't know, sometimes we get, we are limited because we don't know how we are affected.
Yes. Thank you for that question. And I said again, this was something that I learned in my time and upon joining the Electoral Commission, the whole concept of having a voter education program. I think it cannot be done by the judiciary alone. Just the way the Electoral Commission realizes that it cannot undertake voter education alone. It can design the programs, it can control the kind of curriculum, but you've got to take it and get providers within the ground among the people to be able to undertake it on behalf, and that discourse can actually happen. And like I said, we've seen it in the voter education programs where we hire voter educators per ward. And so I would actually say, make it my business to have a legal information, a wananchi legal information program that is actually concerted over time, and ensure that we get resources to undertake this program. Yes, it costs money at the initial as a capital injection, but eventually in the long run, those educated people pass the information. Other countries have also adopted processes where they teach an understanding of the law, the court processes in primary schools, so that by the time people are turning 18, they perfectly understand the law. And therefore, you're not dealing, but right now we have a gap, and therefore we've got to do a quick initiative in Kenya in order to bring everyone up to speed. But for the long term, and for posterity, you can actually introduce it in schools. I know that I have suggested, again, in the Electoral Commission, the same system, that let's introduce it in primary schools, because if you have a highly informed educator, then it's easier to have issue-based politics. But you can't say we want to promote issue-based politics in Vision 2030, yet the people, you need to make them capable of getting involved in issue-based politics. And though that is possible, it is a cultural change. You've got to educate the society. These children go to school. Now, today, the younger people, the literacy rate, nearly all of them are able to go to school. So you can introduce that, but also introduce it through the community programs. Thank you.
Thank you. Now, as Deputy Chief Justice, what mechanism would you put in place to create networking within the East African region, within the African continent, and within the international community, and also to be able to compare the best practices within within the region?
Thank you for that question. Again, it allows me to cover an area I didn't talk about. I am a strong believer in comparing yourself with the best. As a person who strives for excellence, the way you can do it is also compare yourself with others. Sometimes you've got to see the bad practices and then see the good practices, and with the knowledge of the assessment of your own country, you're able to do that. I think it is something that must be promoted. I have seen that in countries like America, and I do know that there are certain judges of the courts of appeals in America who constantly come to Kenya. Their own judiciary makes a deliberate effort of giving them the opportunity and time off work to go and interact with other members of other judiciaries all over the world. What it does is it improves, it's actually part of training, because you can't think in your own little box for a long time. Here you would have, it takes, I know it's very difficult for a judicial officer to be able to get into those kind of programs, but we can encourage those programs, and many of them exist. Many of them are funded. And, but also, it is also important to make sure that the right people are, it comes with, again, planning. It all goes back to planning and saying that these are the groups we want to network with. These are the countries that we want to learn from. What are the opportunities from learning from that? And I think that is possible. Nairobi really is an international hub. Nearly all the leading democratic countries have their embassies here, and you can harness on that to undertake that. One, you're able to get the technical support, and secondly, you're also able to get the financial support. I had the part of my portfolio and job description within the commission is I manage the election donor group funds, and I undertake fundraising. I undertake the reporting on the funds, discussing. I would usually design the projects with all the directors, consolidate that, and try and get funding for it. I think it's very important. I know that at the Electoral Commission, we were able to get technical support. There are people who have gone all over the world designing electoral management systems for other countries. There is no need for us to start learning from scratch. You can pick those people's brains and then be able to implement it. But of course, it's important not to lose that out so that someone else has control of your processes. It is that is my knowledge. I also, in dealing with the development partners who offer technical and financial support to the both institutions that I've worked for, both at the Electoral Commission, at the Kenya Law Reports, and also even within the judiciary, because I did sit on the JG Laws program, which was like a basket fund. And I did learn some lessons from the JG Laws program, which I was able to assist me in improving the way I worked at the Electoral Commission, which is for many times what happened is development partners would come into the country and design the programs for you. What is it? I now know, and over the years I learned that you actually have to put a stop to that. The programs must be designed by the institution itself. At the Electoral Commission, the way we operate is we draw up our own master plan of what we want to do. Then we sit all the development partners at one table and say, this is what we want to do. Take your pick on what you'd like to support us on. So it's us who dictate what we want supported, not the development partners dictating what should be supported and their own programs. And I think that's very important. That experience for me, I think, is something that I can apply. I took several years that I learned it. I know at the beginning, we used to be told, there's money for this, I think you should do it. But over time, I learned, and I am on record of having told the development partners, we're putting a stop at this. If you don't do it our way, we don't need the money.
Thank you. Finally, this panel is looking for a Chief Justice, for a Deputy Chief Justice, yes, who has very high moral character, of integrity and impartiality. Do you think you could be the one?
Oh, yes. Yes, I believe I'm the one. I'm a person of integrity. I have very high moral standards. I have very high expectations of myself. I have always had extremely high expectations. It's my upbringing. It's the way I have always grown up. And so for me, this is second. It's not. I would not be trying to learn to be and have those values. It is values that I've always held. For me, they are absolute values that I can never derogate from, no matter what. Yeah.
Thank you. And thank you, Chairperson.
Gladys, I was scheduled to pose questions in the area of management, administration, human resources, but I think you have explained most of the issues that I would have liked to probe you on. I'm going to ask you general questions.
Yes.
One of the areas I had prepared to ask you questions on is about your 17 years experience since you graduated from University of Nairobi, and the fact that you have worked, you are now working in your 6th organization, starting from international vote consultant, international waters consultants, then you went to Kilonzo. Is it Mutula Kilonzo?
Yes.
You went to Kilonzo, then you went to private practice. At the same time, you were lecturing at University of Nairobi. Then you went to Kenya Law Report as an assistant editor. Then you became the CEO, and now you are the Electoral Commission since the year 2009. And my colleague asked you whether you have staying power in any of these organizations. I don't want to take that line. I want to ask you, when will you achieve self-actualization, or is the reason why there is a very high frequency of movement? Because is that what you are looking for?
When will I receive self-actualization? When you appoint me Deputy Chief Justice.
Right.
That's on a light note, Mr. Chairman, sir.
Yes.
If you look at it, I can say that there's two. What you can actually count me on and pin me on is the Kenya Law Reports, the university, and the Electoral Commission. Why I say that is that that at the beginning, of course, as in one's career, as a young person, law is a very wide subject. You can practically do anything after studying law. Because law broadens you and enables you to have a complete understanding of society. And that's why you can find lawyers serve on the Senate, in our parliament. Lawyers are heads of corporations. Lawyers are in the judiciary. Lawyers are everywhere. And so for me, at that time, of course, there was also, which happens in everybody's beginning of their career, is that trying to search where your niche is. And that's what I did at the beginning. I came out of university. The in thing at that time was environmental law. And so I studied environmental law, public international law. It was a subject that I was greatly interested in. Even though I moved away from it, when you think about it, for me, it exposed me to amazing possibilities. During that time, I was able to, when you study things like environmental law, study maritime law, when you study shipping law, it allows you to actually study international law. Because under shipping or maritime law, when you ruin the environment, if you ruin the seas, for example, as an international waters consultant, anything that you do at the coast in Mombasa will affect the coast in Somalia and the coast in Tanzania. So it brings to play the various laws of various countries. When you look at shipping, you have a ship that has employees from a different country, so you're dealing with the labor laws of another country. It has it is registered under the company law of a different country. It is flying the flag of another country and therefore another sovereignty. I found it an extremely interesting time. I did learn. Of course, as you grow up, when many people will always dream and that you want to practice law, because I do know, I grew up, one of the things that made me study law was watching LA Law. And so I always imagined that I would appear in court, present these cases and so on. So there was that such, and I do appreciate that time when I did those 3 movements. But you can see that with time, when I moved to the university and the Kenya law reports, and remember, working at the university, you're able to work, you can also teach part-time at some point, and so it allowed me I solidified my niche. I discovered that I'm actually interested, I want to be in the legal sector, the academic world, the judicial work, but also management, and that's why I went back to school and studied management, because it was necessary. So I discovered my niche, and I've stayed there. And you'll see that the Kenya law reports, I was there for 9 years. I explained why I moved on to the Electoral Commission, and I've also explained why I've moved at the moment. So I do have staying power. Staying power actually comes with age, and I think I've reached that age. And in any case, the position of Deputy Chief Justice, the work never ends. It goes on until you drop. So really, I don't think you have to worry about staying power on that one.
You said earlier on that when you left the law, Kenya National Council for Law Reporting, you felt that you had given as much as you could, and you had already nurtured the organization to a point where it would continue even without there. Would you say the same as far as the Electoral Commission is concerned, or might the Electoral Commission need you at this time, especially when the challenge is the next general elections?
Yes, that sounds like a conversation my chairman would have with me. But when I look at the Electoral Commission, I ask myself, what was the single most important thing that needed to be done when I joined the Electoral Commission? The thing that needed to happen is to restore voter confidence and public confidence in election management. By the time when we were all appointed as a new team at the Electoral Commission, I had many people say, siwezi kupiga kura tena. They constantly say, it was on the streets every day. But I hear a different message now. If you look, IIEC is currently ranked as the most trusted institution after I think the recent survey, most trusted institution after the media. For me, that is something has happened. It has been done. And so the single most important thing that needed to happen has happened. And therefore, I do not feel like I'm leaving too early. I also do realize that if I think it would be it would almost be arrogant for me to say that they need me, like it would be making it look like I'm the one that makes everything happen. Yeah, I think I make a significant and positive contribution as a member of the team. And therefore, wherever I go, that's the way I look at myself. I don't look at myself as the one and only. And therefore, I would not want to describe myself as need me.
Now, having worked with the Electoral Commission this last maybe 2 years, and then you are involved with the Judiciary for 6 years. So the Judiciary, although you are working from the Attorney General's office, and the Interim Electoral Commission conducted, first of all, the various and also the referendum. And it is true that Kenyans do trust that body. And it's kind of unusual because Kenyans are so skeptical that they don't trust. They are very difficult to satisfy. So you must have had an opportunity to observe exactly what it is that went right at the Interim Electoral Commission. And maybe you can compare that with your experience and interaction with the Judiciary, and identifying maybe what didn't go right and what you would want to come and assist in rectifying if you became Deputy Chief Justice. Would you like to comment on that briefly?
Yeah, I think when you say what went right at the Electoral Commission, I must say that some of the things that go right is simple. Speaking to the public. You will know that our chairman, Hamed Isaac, for whom I have the highest regard, constantly speaks to the public. You will see him in the media. He speaks honestly and with humility. He tells them when there is a problem and tells them when things are going right. And he's also can be firm when the situation calls for it. But his firmness will always be anchored not in arrogance, but in application of the law or firmness within the law. And I think that is one thing that I found right. In my time at the judiciary didn't speak to the media. They didn't speak, you're speaking to the public, you're speaking to Kenyans. And the other thing I learned that went right at the Electoral Commission is that the members of the Electoral Commission were not afraid to say this didn't work. They were willing all the time to admit that we made a mistake here, we need to relook at it. That was amazing. We also, transparency and accountability is also one of the major significant issues at the Electoral Commission. I did see that in when you look at the electronic vote transmission that we undertook, it was a transparency issue. We allowed the media to hook up onto our system and tell them, if there is a problem with it, if some results don't tally, please tell us. We didn't hide it. We didn't say that we are almighty and we are the ones who know it all. We didn't take the results to a back room, make them, and then come and announce it. The public was able to watch results real time, simultaneously, and all of us, from our chairman to the election managers on the ground, were watching the results on screen with the rest of the world. We had no advantage over them. The fact that they knew that we were not manipulating anything, or that it was we were allowing systems to work beyond our control, that made them trust us. And therefore, that is something I would ask the judiciary that would like to learn from, because there is nothing wrong with telling Kenyans we didn't do this right. If there is a problem, we are trying to fix it. They're not going to. Kenyans are willing to forgive you when you're honest. But if you look like there's a mystery around it and you're not going to admit it, then it becomes harder. It doesn't mean that we did work at the Electoral Commission perfectly, but at every stage when there was a problem, and you saw that during the referendum, we had a system where we got what was happening. We were the first people to inform the public that a boat has capsized, but it's under control, they've been rescued. Voting will happen 2 hours late, but we are going to be there. And so for me, just that explanation constantly and interacting, and then also empowering the public and telling them that election management or any work that is being undertaken in a public office is not your territory for you to keep. You have to allow people to participate. At the Electoral Commission, we constantly said, if anybody knows of any malpractices, let us know. If you know of any challenges, do let us know. And that constant asking for feedback. And I think that I did see the judiciary with the KMJA, which I thought was amazing, is to have the feedback from the public, sitting with the court user committees, because they'll tell you. That way they begin to trust you. It is possible at a court users committee meeting, which I was told by judicial officers, that you can say, we have so many cases we can't take up anymore. So you'd have to wait until the diary opens up. When you're honest, people are not going to agitate. They perfectly understand. So those are just a few. There were many learnings that I've learned from the... And
of course, what you're saying is that these are lessons that you would wish to share with the judiciary if you are given an opportunity of becoming a Deputy Chief Justice. I was looking through your documents and I saw a customer or a client who wrote you a letter, and the letter partly read as follows: for me, as the Chinese saying goes, when I drink down the river, I have to realize that upstream, you are the spring. You are being called the spring. The spring is up there. It never quite gets to understand what is happening in the main river. If you are the spring, can you explain to this board how you would make sure that you understand what's happening in the main river, which is a big organization called the judiciary, as a deputy?
Yes, I think being the spring as described in that particular saying is a powerful position, but which also must be dealt with very carefully. It means that the position that you hold impacts other people down the line. It means that whatever you do will affect another person. It could kill them, it could maim them, it could completely be life-changing to them. And therefore, I believe that a position of responsibility such as this has to make you more aware, more than ever, about each and every action that you undertake, because it will affect somebody. And I think I'll carry that with me. I think it's an amazing saying, because you have to constantly remember that you're going to cause an impact in somebody else's life.
Finally, if you are Deputy Chief Justice, would you recommend to the Chief Justice that judicial staff enter into performance contracts?
Yes, I would. Of course, what is important is to make sure that the performance contracting tool that is designed is one that is capable of measuring judicial work, because judicial work is unique. They cannot have the same performance contract as others. I have actually been studying this area of performance contracting out of curiosity, because it's one of the key things that must be done within management, but I also know about the debate at the judiciary whether or not the judicial officers. I think at that time, I do remember speaking to some of the judicial, the fear was they would be measured like any other person. Can you measure a judicial officer and say 100 judgments per week? There could be 100 judgments but not good judgments. There could also be 100 judgments but very unjust and do not apply the law. So I think their measurement tool has to be very key. And what I'm happy, and to the credit of the Right Honorable Prime Minister, when performance contracting was started in the public service in 2004, I think at some point when it came under the docket of the Prime Minister, it was realized that there was a disconnect, and that sometimes service delivery did not realize what was wanted by performance contract. I think must have been a year ago or so, they set up a panel of experts to look at the performance contracting tool. And actually that panel of experts discovered that there was a mismatch between the performance contracting tool and the actual results expected and service delivery. In fact, based on that, I think the tools are being redesigned. If I was within the judiciary and needed to give advice, I would ask that we go back, because I believe in building from what has been developed. Already the public service has gone through it all on this. They started off on good momentum, began to go down a bit, but they had, and again to their credit, to relook at it and say something is not going right. Can we relook at this, and then improved on it? I would be asking the judiciary at that time to make that as a starting point, to understand how it began, how it impacts on service delivery, and then tailor-make it within the work of the judiciary. And I think that tailor-making would be made by people who have served in the judiciary, because they understand that work. That is not something that can be done by an outsider. It has to be members within the judiciary to design it. I would probably use like the KMJA to look at it and say what kind of tool, sitting with experts, of course, who understand how those tools are defined. And so therefore, I would encourage it. I would what do you call the word? I would actually encourage it. I would propose it, but with modifications within the nature and uniqueness of the work of a judicial officer.
Tailor-made
yes.
with the judiciary.
Thank you.
Thank you very much. Thank you very much, Mrs. Shollei, Gladys Boss Shollei. Well, this is the end of the interview, unless any of my colleagues would like to do a follow-up. And whenever there is such an opportunity, I start by looking at the Attorney General. Thank you very much. That if there are no other comments, I would like to thank you most sincerely for answering our questions. I think you have answered them to the best of your ability. I do not think that you have faltered or fumbled in any of your answers. We wish you well. As soon as the decisions are arrived at by this commission, you will know, like as the other Kenyans know, who is going to be the next Deputy Chief Justice. We wish you well, and please make sure that you do your bit at the Electoral Commission, so that we do not start planning how to take pangas again if the election is abandoned. Yes. Thank you very much, and you are free to go unless you want to thank us, which I allow you to.
Definitely, I want to thank you most sincerely. Of course, coming in here at the beginning sounded a bit intimidating, but again, like I said, I'm grateful that I'm part of the history of public hearing process in Kenya, which I think is a fantastic introduction, and I appreciate your time and your questions. You have helped also clarify my issues. I think, Commissioner Ahmed Nasir, I will go and study and maybe one day tell you what my philosophy is on that. Thank you.